Hola amiga, ¿te por ahí por luego?
No, no, eso no es. Tekan langsung gua sih, amikan tekan langsung. Itu namanya job nih jadi gua sih. Lihat jadi foto stick dulu. Before you go. Sir. Jadi gimana gitu?
Hello, sir. Hello, sir.
Oh, then right after the itu utai lebih use boleh nadi. From the utai lebih use nak boleh. Not the first. So, ini jelas jadi utau apa ni? Coba. Ini utau boleh. तो करना अच्छी बताओ बड़े लोग भाई करना अच्छी करेक्टर के ऊपर मुझे लेटर दो प्रोविजन आई मुझे इवन इफ इट्स डोंट जस्ट तो कोई ना सकता no the right of the vacation let us start in the meantime even if it is withdrawn don't discuss हम वही बोल You only next Mother India.
May please Lordship, Lordship, I
Yes.
beg to mention item number 39.
39.
Yes. Lordship, I may be given 3 weeks' time to obtain the status of the case.
39.
Yes.
On the prayer of MS Beek, so
Yes.
learned additional advocate general. List this matter after 2 weeks,
3 weeks, Lordship.
3 weeks
Yes.
to obtain the status of the matter.
Lordship. Much
List
obliged.
after 2 weeks.
Much obliged.
May I please, my lord?
Yes,
Lordship, I beg to mention item number 15.
15.
15, my lord.
Yes,
If 3 weeks' time can be granted to me, your lordship, to receive the necessary instruction, my lord.
you are for
Respondent number 1, my lord.
respondent. Mr.
Ken Angami, my lord.
Nangami, learned counsel. Appearing for respondent number 1. Press for and granted 3 weeks time
Lordship.
to obtain instruction. List
Lordship.
after 3 weeks.
Lordship, I have a similar prayer for item number 25 as well, my lord. Here I am here to receive instruction from the department, my lord.
25. Same prayer.
Lordship, if I may be allowed to mention the hearing item number 54, my lord. I am for the state respondent here, my lord.
Yes,
May it please your lordship.
yes.
Lordship, here there is an urgency, lordship.
What is the urgency?
Lordship, here the petitioner late husband has retired since 2018, lordship. And because of this matter, the pension matters has been pending, lordship. So this may be the last chance, lordship.
Okay.
After the vacation.
Have you filed the affidavit
Yes.
on the prayer of Mr. So and so government advocate?
Lordship.
List this matter after 2 weeks.
Lordship.
MS so and so land council for the petitioner submits that matter relates to, since the matter relates to pension, last sentence should be, it should, the adjournment is to be as a last sentence. List this matter after 3 weeks
Obliged.
as a last sentence.
Lordship. Deeply obliged.
May I please lordship, I may be allowed to mention from part 2 hearing is item 43, 44, and 45, my lord. I beg that these matters may be listed after the vacation, my lord.
No, this is 2016 matter.
Yes, my lord.
Why?
My lord, I need some clarifications from the petitioners
What clarification?
regarding the status of land ownership, my lord. Regarding the,
You are for petitioner.
yes, I'm for the petitioner.
If you are petitioner, you don't know the status of your
No, my
land?
lord. The problem is we lost the context of the petitioners. So I'm trying to locate the address. My lord, only a short time.
You check out, there is a order of this court,
Yes,
similar matter.
yes, yes, my lord.
That may be the reason you are asking for adjournment.
No, my lord. Only short clarification.
This court also forgot whether the writ petition was allowed or dismissed.
Yes, it was dismissed with the direction, it reflects the post,
I hope it's not for that reason.
my lord.
It's not for that reason that this court has passed some orders in similar matters.
Yes, my lord.
Therefore, you want an
Yes,
adjournment.
no, not adjournment. I just wanted some clarification, my lord. I have been informed that a appeal is being prepared for filing an edit appeal.
Sir,
I
this is of 2016
16 years,
matter.
my lord. Very much, my lord.
As a last chance.
Yes, my lord. Yes, ma'am.
1 week.
Yes, ma'am. No issue. I just wanted to clarify whether the appeal has been filed or not. That's all, my lord.
Item 43 to 45. Mr. Your
And
name
Kumar, my lord.
and Kumar, learned counsel to the petitioners, submits that he needs an instruction regarding the status of the land of the petitioners. Therefore, prays for listing the matter after
Vacation.
2 weeks. Please stop, comma. Please stop. Next paragraph. Since the matter is of 2016, this court reluctantly granted prayer. Please stop. List this matter after 2 weeks as a last chance. No further adjournment will be granted on the next date.
Okay. Yes.
Obliged.
Obliged.
May I please, Lordship?
Yes,
Lordship, I may allowed to mention item 50, Lordship.
50.
So I'm mentioning on behalf of my senior, Mr. Imawabang. Lordship is out of station,
Civil revision.
50,
Okay.
for the petitioner.
On the prayer of Mr. Fosico Forte. Mr. Fosico Forte, learned counsel for the petitioner, submits that his senior, Mr. M. Lima Wapang,
Imawabang.
is out of his station. Accordingly, phrase for 2 weeks' time.
Lordship, please.
Prayers are allowed, list after 2 weeks.
Lordship, I may be allowed to mention 46 and 47.
46.
Lordship, the matter is led by Mr. Tang Chuba. 46 and 47.
Hmm.
Lordship, let this matter come up after the vacation, Lordship.
We'll fix this. (2019). Okay, any objection? On the prayer of learned counsel for the appellant. And prayer not being objected to by the counsel for the respondents, list this matter after 3 weeks.
Lordship, also item 34. I'm for respondent 6, Lordship. I'm yet to file my affidavit. Affidavit, Lordship.
Mr.
Kindly grant 3 weeks time.
What is so and so, learned
34.
counsel for respondent number
6, Lordship.
6. Press for some time to file counter affidavit in this matter. Prayers are allowed, list after 4 weeks.
Lordship, item number 5, Lordship. Here I'm for respondent 5. Here also my senior, Mr. Limawabang, is out of station, so Lordship may kindly grant it.
You are for respondent number 5.
Lordship. After vacation, Lordship.
On the prayer of Mr. Fosico Forte, learned counsel for the respondent number 5. List is matter after
Vacation, Lordship.
4 weeks.
May I please, Your Lordship, may be pleased to mention item number 9.
How many items you have?
Only one, Your Lordship.
Just give the number.
Your Lordship, one. Only,
One.
item number 9, Your Lordship.
Item number 9,
Yes, sir. 2 weeks, Your Lordship.
2 weeks.
May I please, Your Lordship?
Yes,
Lordship, I'm mentioning on behalf of me, Wapang, hearing item number 51 and 52.
51 and 52.
Yes, Lordship.
You are for
I'm mentioning on behalf of M. Wapang, respondent claim.
you don't want the money? Compensation?
Lordship, I'm not a counsel here.
Okay. Mr. So and so, learned counsel appearing on behalf of Mr. M. Wabang. Pressed for and granted 4 weeks time. List is matter after 4 weeks.
Obliged, Lordship.
Yes.
With please, Lordship. Lordship, I beg to mention item number 11.
11. Yes,
This matter will be listed after summer break, so as to enable me to complete the affidavit.
Mr. So and so, learned additional advocate general. Phrase that this matter may be listed after 4 weeks. List this matter after 4 weeks. Prayer not being objected to by learned counsel for the petitioner.
I have a similar plan, item number 26.
26. And
26 only.
26,
Your
similar. plan.
Lordship, let the interim be continued.
26, earlier in, interim order pass shall continue.
May I please, Your Lordship?
Yes.
Lordship, I beg to mention item number 16, Lordship.
16,
Here, the state is yet to file counter, Lordship.
so and so, press for it granted 3 weeks times to file counter affidavit.
Lordship.
Any interim order? No.
May I please, my lordship, item 37.
37,
Lordship, may it be listed after 4 weeks, lordship.
after 4 weeks.
And item 42 also, lordship.
42, yes, after 4 weeks.
Pleasure, lord.
Yes, your Lordship, your Lordship, I will mention item number 14.
40,
1-4, your
1
Lordship.
4.
Your Lordship, pleadings has been completed, hence it may be fixed for hearing after vacation.
Hmm?
Pleadings has been completed, your Lordship.
Okay. Now we'll fix it for admission. What is the matter?
Yes, your Lordship. Your Lordship, here, the petitioner's compassionate appointment was
Compassionate
cancelled.
appointment.
Yes, your Lordship.
Admit this petition, list for hearing
Your
in
Lordship.
usual course. Heard so and so, so and so.
May I please, Your Lordship?
Yes,
Lordship, I beg to mention item 31, 31,
31 and
31.
31 and only 31.
Yes, Lordship, for respondent number 4, that is the NPST,
Okay,
we are yet to receive the Paraguay's comments.
yes.
Lordship, this matter needs
Urgency.
expeditious disposal. I took 31. What has happened is we are disputing before this honorable court the 3 posts for the backward quotas.
Madam, if you are disputing, go to civil court.
The thing is, they have even withheld the general category who have been selected by the
So in that
MPSC.
case, we did,
Emergency.
they need to file counter affidavit.
Lordship, that's why this may be the last time. Last chance for the respondents.
MS so and so learned counsel appearing on behalf of respondent number 4. Who prays for listing the, who prays for some time. So as to enable her to file counter affidavits in this matter. Please stop. MS Judge Zimobi, learned counsel for the petitioners, submits that there is an urgency in the matter. Therefore, it should be, the time should, if granted, should be as a last chance.
Lordship.
However, this court finds there's a matter of 2020 and the issue involved is needs the,
NPSC pass recruitment.
okay. Needs the counter affidavit of the respondent number 4 is required. Therefore, list this matter after 4 weeks so as to enable the respondent number 4 to file the counter affidavit.
Lordship, interim order the date 16/12/2022.
Interim order.
Continue till further orders. Obliged.
Will not say till further order. Was it for till returnable date?
Yes,
So we'll say till next date.
Lordship. Obliged.
Please, your Lordship, I beg to mention item number 22.
22.
22,
Yes.
your Lordship, I'm for respondent 6 to 37.
Hmm.
Kindly grant 3 weeks time to file a counter.
Okay. Any objection? No. MS so and so learned counsel for respondent number 6 to 37.
37, your Lordship.
Who phrase for time to file counter affidavit, list this matter after 4 weeks.
Lordship.
Praise allowed, list this matter after 4 weeks.
Lordship, I would like to mention item number 17.
17.
We have received the affidavit in opposition today. Kindly give us 2 weeks time to file our reply.
Yes. MS so and so learned counsel for the petitioner. Submits that she has received the counter affidavit filed by the state respondent.
State respondent.
for which she needs some time to file affidavit in reply. List after 4 weeks.
May I please, Lordship? Lordship, I beg to mention item number 29.
29,
Lordship, I'm here to receive instructions, so Lordship, we kindly grant 3 weeks time.
2 weeks time granted to the learned government advocate to file counter affidavit.
Last chance, maybe.
No less sense. We'll see after 3 weeks.
I pledge.
May I please, Lordship?
Yes.
Lordship, I beg to mention hearing item number 48, Lordship.
48.
Lordship, on behalf of VTO, if this matter may be listed after 3 weeks, Lordship.
Your name?
Lordship, I'm appearing on behalf of VTO.
BTO. Mr. So-and-so. But you must have,
Luckily form, Lordship, luckily form.
okay. Appearing on behalf of Mr. BTO, learned counsel for the appellant, who pressed for and granted 3 weeks time.
Lordship.
List this matter after 3 weeks.
And Lordship, I also beg to mention item number 21, Lordship.
21.
Here, Lordship, I am here to file my affidavit in opposition, so if this matter may be listed.
You are for respondent number
Respondent number 6, Lordship.
6. Mr. So-and-so, learned counsel, appearing for respondent number 6, phrase for and granted 6 weeks time, 4 weeks time to file
Lordship,
counter affidavit.
Lordship.
List this matter after 4 weeks. Yes, 4 weeks.
May I please, Your Lordship?
Yes.
Lordship, I beg to mention item number 4. I'm for respondent number 4. Lordship is for filing of the amended affidavit.
Yes.
I have sent a draft copy for waiting, still waiting, so Lordship, please to give 2 weeks time.
Mr.
Your Lordship, if this may be the last time granted, because the amended affidavit just needs a slight rectification, there's nothing much that the respondent has to do in this matter.
Yes.
So if this be the last chance granted to the respondent parties for filing the same, Your
It's
Lordship.
just to, it's a clerical mistake.
Lordship.
Why do you need 2 weeks time?
Lordship,
In
1 week will be
in
given
that
for that.
case, if you want to file a counter affidavit or proper amended petition, you will ask for 7 months.
Yes, Lordship. Lordship, what happens
Is
is
it?
that the Union of India, it goes from one authority to another, so the by the time it reaches, so it's okay. 1
Anyway,
week, I'll take this.
is directed by this court on so and so, which date? This letter counsel for petitioner pressed for another 2 weeks time to file the amended affidavit.
Lordship.
Praise the Lord, list after 2 weeks as a last.
Lordship, let it
Lordship.
last.
Grateful, Lordship.
Yes, it's 2019 matter. Yes,
Your Lordship, I beg to mention item number 34.
34.
Yes, Your Lordship. State is yet to file affidavit, so kindly grant me 3 weeks time.
34 already mentioned. You just 34 add that she also pressed for 4 weeks time to file counter affidavit on behalf of the state. Yes, it has already been mentioned.
Lordship, there's an interim.
Interim order. Past the arrest shall continue.
Your Lordship, item number 28, on behalf of Inaoli, kindly grant 3 weeks time to file affidavit.
28.
Yes, Your Lordship.
Yes, same prayer.
Item number 24 also,
24
on behalf of Sepong Chang, kindly grant 3 weeks time to
Same.
file affidavit.
and
24,
24 and then
28.
28. Then you just give the number.
That's it. Your
Same
Lordship.
prayer.
Please, Your Lordship. Your Lordship, I beg to mention item number 10. Kindly grant us 3 weeks time to file our reply.
MS so-and-so learned counsel appearing on behalf of the petitioner who pressed for some time to file affidavit in reply to the counter affidavit filed by the state respondents. Prayer is allowed. List after 3 weeks.
I also beg to mention item 18,
18,
our affidavit in opposition.
18 you are for
Respondent,
respondent.
yes,
18.
yes.
What is this IA? IA is for what? Who is appearing for petitioner? You are for respondent.
My senior is for respondent.
Respondent number?
Uh, 5.
You just give MS so and so
5.
appearing on behalf of Mr.
Gauhati.
Yangarvati. For respondent number so and so.
5.
Respondent
Respondent.
5. Press 4 and granted 3 weeks time to file counter affidavit.
Applied.
Your Lordship, item number 12, here pleadings are completed. So let the matter come up after 3 weeks for admission hearing.
Okay. What is the matter?
It's for pension.
Pension. 2 weeks.
Malad.
If it's pension, we'll admit and we'll, listen for hearing.
Malad.
Is it?
Malad.
Heard Mr. So and so, learned counsel for the petition as also, and also heard MS so and so, learned government advocate. Admit this petition, list for hearing after 2 weeks.
Much obliged.
May I please, Your Lordship, I beg to mention item 30, Your Lordship.
30.
If 2 weeks time will be given.
You are for
We are for the petitioner.
MS so and so, learned counsel for the petitioner.
Your Lordship, we are yet to file affidavit in reply.
Learned counsel for the petitioner. Phrase that she may be allowed 3 weeks time to file affidavit in reply. Phrase allowed, list after 3 weeks.
Your Lordship, I have a similar prayer in item 33 as well.
33, similar prayer. You are for petitioner?
Yes, Your Lordship.
Yes, then? That's all.
Yes.
Yeah.
Much obliged.
Yeah, please, Your Lordship. Regarding item number 9, there is an interim. So kindly extend the same.
What interim?
And item number 9,
What is the interim?
Your Lordship, it's staying the seniority list.
Why it should be, seniority list should be stayed. Should allow to go on.
Your Lordship, the petitioners are barred from promotion because of the seniority list.
Okay. Interim order, past order shall continue. Item 9.
Much obliged.
Yes.
This Lordship, I beg to mention item number 13 on behalf of my senior Moa Jamir, counsel for the petition. Lordship, we have received the affidavit of opposition filed by the government. Kindly grant us 2 weeks time to file a writ.
Mr. So and so, learned counsel appearing on behalf of Mr. Moa Jamir, learned counsel to the petitioner. Press for and granted 3 weeks time to file the affidavit in reply to the affidavit opposition filed by the state respondents. Just after 3 weeks.
Lordship, I beg to mention hearing item number 49 on behalf of the appellant. Lordship, let the matter be fixed on the 18th of July this month.
On the prayer of Mr. So and so, learned counsel for the appellant. List this matter on 18th 7/2023.
Obliged.
Please, Your Lordship. I beg to mention item number 19.
19.
We have received affidavit in opposition. Filed by the,
You want to file affidavit in reply? MS so and so.
Lordship,
Any
as far as
objections?
the state respondent is concerned, we have filed a complaint affidavit. We have filed a complaint affidavit, and to that effect, they want to file a reply
Okay,
filed by the state respondent.
okay. Is it writ petition?
Lordship,
Then why compliance affidavit?
Lordship, on the last occasion, this honorable court has directed the state respondent to file a complaint affidavit with regard to the compensation, Lordship.
Okay. MS so and so, learned counsel for the petitioner. Press for 3 weeks time to file affidavit in reply. to the affidavit, a compliance affidavit filed by the state respondents. Praise the Lord. List after 3 weeks. Yes.
Made resolution.
Yes.
This is also a revision, civil revision petition. Challenging the order passed by the learned principal district and session judge.
Yes.
Dated 23/6. Now, your lordship, the fact of the case is that, your lordship, my father entered into an agreement and conveyed a plot of land measuring 50 acres way back in 1985 during his lifetime to Industry Department, Nagaland, on condition that Industry Department would have their citronella farming project in the land. My father actually handed over the land, taking into consideration that if the citronella farming comes there, and then my villagers will be taken on employment. However, your lordship, there was a clause in the sale deed, clause number 6, date 1985, wherein it is categorically stated that if the land is abandoned or diverted from the project, then the land will be returned to the owner.
Yes.
This is contingent contract, your lordship, under section 32. Under section 31, it stipulates about contingent contract. And under section 32, it says about the contingent contract when that takes place, then it will be effective. Now, the opposite party is coming with the plea that before that, the opposite party, they have given the land to railway, diverting from the project. Now, railway is giving has given compensation through Deputy Commissioner, pro forma respondent number 1 and pro forma respondent number 2, railway. We are not against development, this railway project, we are not against that. But there are it is a breach of that agreement which was executed way back in 1985. Now, your lordship, that agreement is that
Page 60,
page 60,
16.
16. Now, typed copy will be 18 euros. 18.
Yes.
Now, your lordship, that clause 6, in the event of department fails to continue the said project and if abandoned, the said land shall be returned to the landowner. So that was the contingent contract, your lordship. Now, what happened? As soon as they have handed over the land to the railway department against compensation, against land compensation, then your lordship, it is contingent contract is very much clear that the cause of action started there from therein. Now, the opposite party is coming with the plea that it is a voidable contract. But contingent contract, it is not voidable. Otherwise, section 29 of Indian Contract Act, it says, stipulates that voidable contract is not valid. I agree with that. But section 32, my case is covered under section 32 of Indian Contract Act, your lordship, which is about contingent contract. Now, anyway, your lordship, in the meantime, this pro forma respondent, they have released compensation amount in favor of the pro forma respondent number 1, that is department. Now, we filed a civil suit before the civil judge senior division Dimapur, Nagaland, wherein we also filed one petition under order 39 rule 2, restraining the deputy commissioner Dimapur, Nagaland not to release the amount to the department. Now, this court below has taken into consideration of the golden principle of that order 39 rule 1 and 2 has issued injunction order with direction the deputy commissioner Dimapur not to release the amount to the department until and unless this suit is taken up. Now, your lordship, that order has been assailed by the opposite party before the principal district instance, Judge Dimapur, Nagaland, and wherein this honorable principal district instance judge, by the order dated 23/6/23, have set aside that
Injunction order.
injunction order.
Yes.
And now, if the amount is being paid to the department, then there is no case of mine. And actually, your lordship, the honorable court of principal district administration judge, by this miscellaneous petition, this IA has already decided the case. Already, and this is the proposition of law is very much clear that by a IA or a civil miscellaneous case, main suit cannot be disposed of. But though impliedly, though there is no written order that main suit is disposed of, but it has become infructuous now. If the money is being used by my opposite party, then I'll be no here. And irreparable loss, your lordship, I am suffering because there is a provision that clause number 6, if they divert from the project, now certain project they have diverted, they have given to the railway, and now compensation. I am entitled
They
for
have
the
given
compensation.
it, given to the railway for what project?
For railway line.
It's more important.
No, use, it is more important, yes,
It's
your
no
lordship.
one's private use.
But your lordship,
It's not individual use, it's public.
yes, your lordship.
Railway line,
I
railway
agree to
track.
that, your lordship. I agree to that. But the breach of that condition of clause 6, your lordship. Compensation.
We can understand fails to continue the project. But then if abandon is something which they have not.
Lordship, no.
They have, but here is the question, your lordship.
They have put it to a public purpose.
Yes, your lordship. Then am I not entitled for the compensation, your lordship? And this is to be decided only after adjudication of the main suit, whether I am not entitled or not, your lordship.
Yes.
No, my lord, there is only two questions of law. I'm representing the state respondent number 1 and 2 have been engaged for this particular case since 2019, lordship.
Yes.
The first question is, lordship, whether there can be absolute restraint in the transfer of property. Of course, the act as it is said to be not applicable in Nagaland, but the spirit of law, can we say that the principle of law is not applicable? Absolute restraint where there is outright purchase, lordship. Not even a single rupee that the department, the state owes the village, lordship. So by this very condition, abandonment of land, lordship. Coming to the second point, lordship, the first thing is, as I've already mentioned, your lordship, is an absolute sale. So when there is absolute outright sale, absolute restraint itself is voidable, lordship. It is not other contingency contracts like insurance and all, lordship. It's a different issue, lordship, on land, property. Number 2, lordship, it is a public project, as my lord has rightly observed. Now, where there is a public development going on public interest, can we say that it may amount to abandonment of land? We will not give the land for public development. The department has no choice. The state has no option, lordship. So, my lord, in fact, the petition in the first place, the suit itself is infructuous. But, lordship, we may be allowed to dispose of this matter as early as possible, lordship, by fixing the earliest date. Because it has been going on since 2019, lordship, after the money has been released by the railways.
Now, your lordship, I am aggrieved that if the compensation is being given for the land.
Let us see the impugn order.
Impugn order is 224.
227, lordship, 227.
227. Yes.
Party H 230 will be the.
The operative portion
Limit
was,
was-
begins from 2:30. Lord.
2:30.
It's a very brief order, my lord.
Should I read it?
Yes.
It is further submitted by the learned counsel for the appeals that the learned court below, in not considering the objection raised by the appellants that the land has been outrightly purchased and as such, having given up all his rights and title over the land in question, the opposite party number one cannot
Outrageous.
claim the land as an agreement. Do not empower it. Further, the land having been outrightly purchased and the sale deed registered, which means that the transfer process is concluded and renders the clause 6 void as per the provision of section 10 of the Transfer of Property Act. Now, your lordship, Transfer of Property Act is not applicable in the state of it has not been adopted till now.
That principle will apply, the spirit will apply.
But your lordship, in
Is there any other law?
Yeah, Article 371A, it categorically stated that your lordship, no act of parliament is enforceable in the state of Nagaland until and unless adopted by the state through a resolution regarding land matter also included there.
But there is a referencing
But,
matter,
but,
69.
but your lordship, herein.
Referencing versus state of
Yes,
Nagaland.
yes, yes, your lordship.
Of course, it's about CRPC and
CRPC and
CPC.
CPC, yes.
CRPC basically.
Yes.
But then the law will apply.
Principle, yes. Lord.
Principle of law will apply.
Now, your lordship, that pertaining to the land, your transfer of property act, just recently, your lordship, SRPC was not applicable in the state of Nagaland, but just recently it was adopted.
Anyway, that is another issue which you
Yes,
may
yes,
take
yes.
call on at the appropriate stage.
Okay, your lordship.
Continue.
Yes, sir, the learned counsel prays for quashing and setting aside the impugned order dated such and such passed by the learned such and such. Everything out from such and such. Par contra, supporting the impugned order dated 8/4/2023, it is submitted by Mr. P.D. Paul there. The learned counsel for the OP1, that the act of giving away the land to the railways amounts to discontinuance of the project and the same being abandoned should have been returned to him so as to claim the compensation. Now, main thing is compensation, your lordship here. It is
You are not interested in the land, only the
only the
compensation.
compensation because as per rule 6, your lordship.
See, if you are not interested in the land, unless you have the ownership, how you can claim for compensation?
Now, your lordship.
First, you have to establish
Yes, your lordship.
that you are the ownership and you are entitled for the compensation.
Yes, your lordship, because
Compensation is it's absurd.
your lordship, here this clause 6.
So if you are not interested in the land, forget it.
Because your lordship,
Compensation is absurd.
now your lordship.
First, you have to establish that lands belongs to me and you are the,
Yes. Now that ownership is to be.
legal owner.
Decided, your lordship, ownership is to be decided in the midst. Whether this clause 6.
But you said you are not interested in the land.
No, your lordship. Now, I am not against the development. your lordship.
Your suit is about the land or is it for compensation?
Both land and compensation, your lordship. Now, your lordship, my problem is that I am not, I am not against the development of the states. Railway line going on, no problem for them. Then, your lordship, why they have entered into this agreement, clause number 6? And as per clause number 6, I am entitled to the ownership of the land. So it is to be decided in the main suit, your lordship. Now, para 6. I have considered the above bridal submission advanced by the learned counsel for the parties. The learned counsels have made lengthy submissions, and when the appellants claimed that the plot of land was outrightly purchased, the OP number 1 claimed that it was conditional sale agreement. The appellant further claims that section 10 of the Transfer of Property Act renders the clause 6 of the sale agreement 1985 is void, and whereas the OP number 1 submit that his case is covered under section 32 of the Indian Contempt Act. The learned counsels also submitted a number of authorities in support of their above submission. However, the above submission are not done in.
According to you, Transfer of Property Act is not applicable.
Yes, your lordship.
It's not been adopted.
Yes, your lordship.
And the Indian Contract Act, it's
Yes,
adopted.
yes.
Is it
property
adopted?
of background, it is.
Is it adopted?
Yes, your lordship.
Indian
It
Contract
is, your
Act.
lordship.
It is property of background. Since system of the state 1963, it was Indian Contempt Act is coming. Now, your lordship, my whether I am entitled to compensation or not. This is coming later on. First, whether this is a contingent contract or this is a voidable contract. But this is to be decided after taking the evidence. Your Lordship.
My lord, may appreciate the paras 7 and onwards also. It's a very short.
Yes, I'm going through that. So, be that as it may, it is seen that the instant case revolves around clause 6 of the stated sale agreement dated 25/9/1985. This clause stipulates that in the event the appellants fail to continue with the project and if abandoned, continue with the project and if abandoned, Your Lordship, the said land shall be returned to the landowner. Meanwhile, the new railway line of Dhansiri-Jubja was approved by NFL Railways, and the same is crossing the land purchased by the appellants, for which the appellants agreed to give portion of the land for the new railway line. It was only when the issue of compensation cropped up, the opposite party now started claiming that the land is abandoned and he is to claim the compensation. At the very outset, I am of the considered opinion that giving or parting with a plot of land in the instant case on which the new railway line process cannot by any stretch of imagination tantamount to abandonment of land. I have fortified in my above view by the following reasons. Though it is submitted to the Land Council for opinion number 1 that after execution of the sale deed and handing over the portion of the land, the appellant started citronella farming, but after a few years, the citronella farming discontinued in certain parts of the land. However, it is submitted by the Land Council for the appellant that no portion of the land has been abandoned and no condition in the sale deed has been violated by the appellant. It is further submitted that the periodic cycle cultivation of citronella should not be construed as abandonment of the portion of the land. Thus, from the proceeding, it can be safely concluded that there was no abandonment of the project and the land by the appellants, and the giving and or parting with the plot of land by the appellants to OP number 3 is out of necessity for the larger interest of the state as the new railway track is being laid the Dhansiri-Jubja BG. As such, where there is no abandonment of land, clause 6 of the sale agreement dated 25/9/1985, which was registered at Kohima bearing registration number 27, dated 11/3/1986, cannot be enforced. The corollary is that the balance of conveyance shifts towards the appellants and that no irreparable loss is because to the OP number 1. Accordingly, in view of that, proceed appeal succeed and the interim order to censure arising out substances thereby. Now, this is the finding of the Honorable Court vision.
Why revision? It is not an appellable order.
Actually, Your Lordship,
It says it's the first appeal. It was in first appeal.
yes, actually, Your Lordship,
There is another issue,
they filed under
procedural issue.
they filed under 43 Rule 1, redo it section 1 of the Code of CTC, which is challengeable. This court passed order under order 39 Rule 1. This is challengeable before the Court of Principal District Judge under order 43 Rule 1R, redo section 104 of CTC.
Okay.
So, Your Lordship,
At this
then the
stage,
matter may be fixed for a finally disposed, Your Lordship.
you would like to file some objection.
All the materials are here, lordship.
Okay. So we'll issue notice. Performer respondent,
Yes, Your Lordship.
do we need to issue notice?
Yes, Your Lordship.
I'll accept notice for performer respondent number 1.
Something. Okay, I will start to.
In fact, lordship, the performer respondent, especially the Indian Railways, their appearance, if they can appear good, even if they don't appear, lordship, there is no grievance against them by any of the parties, lordship.
Since he is appearing.
That is for
It's
the
for the
Deputy
purpose.
Commissioner Dimapur, lordship.
TR 1.
One.
Former respondent 1.
You are for 2.
1 and 2.
No, no, he is for 1
And
and
for
2.
the
If
main
the
respondent,
respondent
1
1
and 2.
main-
Okay, state and the directorate.
Yes, lordship.
Okay.
Actually, Your Lordship, I do not know whether the money is released or not. My friend will be knowing. If the money is released, then there
Then
should not be-
it should not be, if the money is released, let it be kept with the department without dispersing, Lordship,
Yes.
so that we can dispose it off with urgency, Lordship, for the sake of fairness, even for my learned senior friend representing the appellant's, Lordship, the revision is.
Okay.
Thank you. Yes.
Mr. PB Port, learned counsel for the petition, and also heard Mr. Joshua Seki, learned counsel for respondent number 1 and 2.
My lord.
And also heard Mr. Kiangami, learned counsel for former respondent number 1. This is impugn order is page 227.
227 years, Lordship.
By filing this revision petition, the petitioner had challenged the order dated 23/6/2023, passed by the Court of Principal District Judge Dimapur. Whereby the temporary injunction granted by the Civil Judge Senior Division in IA number 238 of 2021, arising out of title suit number 3 of 2021, has been set aside by allowing the first appeal number 01 of 2022 filed by the respondent number 2,
1 and 2.
1 and 2. Next paragraph. The case of the petitioner projected in this petition is that on 25/9/1985, the father of the petitioner had parted the land to the respondent number 2 by way of sale deed duly entered into between the parties listed. In the sale deed, not in the, with the condition that if the project for which the land was sold and on its abandonment, the land shall be returned to the father of the petitioner. Mr. The respondent number 2, according to the petitioner, has discontinued the project and abandoned the land, for which, as per the contingent agreement contract, the land ought to have been returned to the petitioner. Mr. The petitioner has filed a title suit before the civil judge senior division, Dimapur. For what is the title? It's for title of the land. Suit is for
Suit for right
and title of the
on the land.
ownership of the land. And also file miscellaneous application or interlocutory application for temporary injunction.
Yes.
That the compensation released by the performer respondent number two to the respondent number two should not be dispersed or released
Performer respondent number one.
by respondent number one and two. Mr. However, I guess that the civil judge senior division has granted the injunction, temporary injunction to that effect. However, on appeal by the respondent number one and two, the principal district judge has set aside the
Yes, Lord.
principal district judge, Dimapur, set aside the temporary injunction granted in favor of the petitioner. Hence this revision petition before this court. Next paragraph. Mr. Joshua Sheki, learned counsel for respondent number one and two,
No, Lord.
submits that the learned principal district judge has allowed the appeal of the respondent one and two which is in accordance with the law. Mr. He submits that. What is your submission? That
Lordship,
it is
Number
not,
one.
it is not a contingent contract.
yes, Lordship, it's an absolute and outright purchase. So absolute
he submits
restraint
that-
is illegal.
The contract is an absolute purchase. A sale is an absolute purchase. And
Lordship, it is absolute restraint in matters of transfer of property, absolute restraint in the terms of the agreement. That itself is null and void, Lordship.
okay.
Absolute restraint.
No, would you keep your that argument for
Yes,
later
Lord.
point
Lord.
of time?
It was an
What do you
outright
say for the
purchase in the first place, Lordship. Number one, outright purchase. Or
Submit-
absolute
submit
purchase, as
that-
my lord has mentioned.
Submits that the sale is an outright purchase,
My lord.
and there's no question of abandonment,
Yes, Lordship.
as the land still belongs to the respondent number one and two.
Yes,
As
and
per
that
the
portion of land has also been given out for public development, public
And
interest. Lordship.
only portion of the land has been parted with the respondent number, performer respondent number two
Yes, Lordship.
for public purpose.
My lord.
Mr. Issue notice. Returnable by 4 weeks.
No, Lordship. Since the respondent number one and two and the performer respondent number one is already
No,
represented.
that I'll say.
And
It should-
performer
No,
respondent
when
number
it
two,
should be returnable, when it should. be.
Lordship, in 2 weeks.
I'm going out. I will
Issue
be back by-
notice returnable in 2 weeks.
Yes, Lordship, 2 weeks.
Your lordship, I'm going out for my eye problem and I will be back by 23rd.
Then 3 weeks. Let us say 4
23rd
weeks.
July, I'll be back. Or
Returnable-
25, 26 anyway.
Returnable in.
Let us fix a date if my lord may kindly. If my lord may
It's a
kindly.
first, it's a fresh case, we'll see. Returnable in 4 weeks.
Lordship, the compensation amount has been pending since 2019, my lord, so at least a date may be fixed, Lordship.
So have you seen there are 2016 matters also?
No, Lordship, that is understood, Lordship. But why should the money be kept like that, my lord? Unnecessarily.
No, we'll try 4 weeks. It's
My lord,
it's a
my-
normal.
Mighty state is having used mighty state.
Anyway,
is
3
not
weeks,
very rich,
returnable in 3 weeks.
And I'm a poor
Since
citizen.
Mr. Joshua Seki, learned counsel for the learned counsel appearing on behalf of respondent number 1 and 2.
My
No
lord.
formal notice need be served. However, the extra copies be furnished to the learned counsel for the respondent number 1 and 2. Respondent number, performer respondent number 1 is being represented by Mr. K. Angami, learned counsel for the learned state council.
I'll sub the copy to you.
No formal notice need be served to him, however, extra copies. Steps upon respondent steps for service upon performer respondent number 2 be served within 2 days.
I'll serve to the standing council.
Whatever. Will say. Having heard the landed next para, having run the landed counsel for the petitioner and the respondents. Come on, in the interest of justice. We'll just say, will not they stay as such, but we'll say not to disburse the compensation amounts.
No, Lordship, the money released should not be disbursed. The money released to the department should not be
Yeah.
disbursed.
Compensation amount released by the performer respondent number 2 may not be released,
Disbursed.
No,
may not be.
no, it's
disbursed.
already released to the performer respondent number 1,
That's what I'm
Lordship.
saying.
So, Lordship,
The amount, the compensation amount released by the performer respondent number 2 shall not be disbursed. Released to the respondent number 1 and 2.
yes, released
shall
to
not
the
be
respondent number 1 and 2, yes, Lordship.
disbursed till returnable date.
My lord.
Much obliged, your lordship.
Lordship, Lord.
May it please, your lordship.
Who is the respondent number?
Lordship,
Who is the appellant?
yes, lordship.
Lordship, the appellant for.
Will allow. Will allow this application. Who would you like to file objection?
I have no objection, Your Lordship.
Okay. Or Mr.
Imti Wapang, your lordship.
Imti Wapang, learned counsel for the applicant and respondent claimant, and also heard MS so and so, learned counsel for the appellant, opposite party. By this application, the applicant pressed for a permission to withdraw 30% of the awarded amount of rupees 19,49,364. $25,000 we cannot. You have asked for 25 plus that is statutory deposit that we cannot.
Yes.
Will not mention that, though you have mentioned here. That cannot be permitted. Which is lying with the registry of this court. On the deposit made by the appellant. The prayer not being opposed by the counsel for the appellant. This application is allowed and disposed of, permitting the applicant respondent claimant to withdraw the 30% amount of the awarded amount of rupees so and so, 19,49,364, which has been deposited by the appellant by proper identification. Is it? IA disposal. Is it the procedure? Proper identification.
Verification.
Okay. Verification or identification?
Both.
Okay.
Obliged.
Proper identification and verification. Sir, have you complied?
Your Lordship, here, as per the order dated 2nd May 2023,
Yes.
we have taken some steps.
Okay.
But Your Lordship, there is a little difference.
Okay.
Because as per the order dated 2nd May, our respondent were directed to exercise to take step in regards to the option number 1. But number one. But Your Lordship, by that time,
Which order?
order 2nd May 2023.
Okay,
That is mentioned in the paragraph number 7 of the order. So as when the order was passed, means directing the respondent to exercise the option number 1 as per the one inquiry. So by the time the respondent, we have already gone to some certain action in regards to the option number 1. Option number 2. So in the meantime, we will file the affidavit as to why we are exercising only on the option number 2. Because as when the order was passed, the option number 2, that is number 1, avail of backward certificate. 1 and 2 of the option and option number 2, clause 1 and 2 and option number 2 of the one-man inquiry has been already exercised by the respondent. So we'll explain as to why we are not going by the option number 1, or we have already come to the option number 2. So Lordship here, as per the option number 2, there are 8 clauses. So we have already implemented.
so you file the affidavit.
Yeah,
You want to
yes.
file the affidavit.
Yes, and again, Your Lordship, again, this matter, because of the seriousness of the issue, we have already again put up to the cabinet again this time also. So
So you
request
think all
that-
those developments and other relevant actions you have initiated
Yes,
placed before this court by filing affidavit. Is it?
my lord.
Heard Mr. MS
It's to your lordship.
learned counsel for the petitioner and also heard Mr. Imsong learned additional advocate general for the state of Nagaland. This court on 2/5/2023. On the prayer of the learned additional advocate general for obtaining instructions as regards the further steps taken by the administration with report to the first option and as to whether the administration can settle the displaced summis at other suitable lengths at the earliest. Mr. Comma. The respondent number 1 directed to apprise this court about the availability of suitable land at disposal of the state for settlement of displaced summis in the district of Kipra or any other district of Nagaland. List of para. Today, Mr. Imsong learned additional advocate general submits that. He would like to file affidavit, bring on records. The action, the steps taken by the state with regard to the options in the options as recommended by the one-man inquiry committee. Stuff. Prayer not being opposed by the learned counsel for the petitioner. List this matter after 4 weeks.
4 weeks.
So as to enable the learned additional advocate general to file appropriate application, bring on records the steps taken by the state respondents, respondent number 1 before this court. This matter after 4 weeks.
Item number 6. Lordship, the parties are ready for.
Yes. How long you'll take?
May not be that long, Lordship.
See, madam, you have been already granted the relief by this court, which they have not complied.
Yes, Lordship.
So there's a contempt.
Yes, Lordship.
By this application, you are challenging the addendum,
Addendum,
which is a part of the policy of the state.
Lordship.
Number two, you are also challenging the list of
List of
applicants.
competition document.
Are you, don't you think that these issues, unless you show something arbitrary, of the addendum, which is the part of the policy of the state,
Lordship, I will satisfy my lordship.
can you, since you have already, relief has been granted to you, can there not be state, can we not ask the state to comply this order of this courts?
Lordship, I pray that I have approached this honorable court challenging the addendum because this addendum is affecting the whole department in the state, where after this addendum, those who have died 20-30 years back, and those who were not even born have applied after this addendum, they have applied for compassionate appointment, and the respondent, especially I have to be factual before this honorable court, those more to do with those bureaucrats, the head of the departments, all the families, those who have died long time back have been put in the compassionate appointment list, and all the immediate expiry petitioners have been set back to exactly in this writ petition, where the petitioner is at serial number 1 to go by the application. I will show my lordship that those who have not applied, they have listed all the names that have died way back in 1991, more than 30 years. And they have set back the petitioner application. He is number 1. Those who have not applied, those who have not been born, those who are neither the present compassionate appointment is for the sons, daughters, and parents.
Okay, that I'll hear later. I'll just ask him.
Yes.
Mr. Simpson. Yes, Your Lordship. Why you have not complied the order of this court? We'll take up the contempt first. Why you are not, have you filed any appeal against this order of this court?
My
That
lord,
is
in the contempt, I'm for the response.
contempt.
We have compiled a fresh list as per the direction of this honorable court. But in view of the addendum, which says that the applicant should be considered on the basis of date.
When
of
the addendum was when?
2019.
19. And this court's order?
2020.
2020.
So in view of the addendum, we have to comply as per the.
What was the order of this court? Let us see first. Then we'll proceed.
To appoint the petitioner within 2 months, lordship.
Where it is?
Page 7, lordship, the operative portion
Of the contempt.
of the contempt petition.
Contempt is contempt 24 of 2020.
Yes, lordship. Operative portion is at paragraph 9, lordship.
Just wait, just wait.
Paragraph 6. Page 8.
Petition. Okay. Page 8. Yes,
Paragraph 6, allow me to read out, Lordship.
yes.
Having heard the learned counsel for the parties and on perusal of the materials available on record, and with consent of the learned counsels appearing for the parties, I deem it appropriate to dispose of this writ petition at the motion stage itself with a direction to the respondent number 3, namely Director General of Police, Government of Nagaland, to consider and dispose of the application stated to have been submitted by the writ petitioner immediately after the death of his father on 28/10/2016, praying for appointment on compassionate ground within a period of 2 months from the date of receipt of a certified copy of this order. Now, after this, they showed my name at serial number 66. And
Where is the consideration? Just showing the name will not do.
My lord,
Any exercise has been taken?
yes, my lord.
Where it is?
Page.
Within two months, you have taken the step, have you complied within 2 months? Or have you considered within 2 months?
Yes, my lord. A board was constituted to examine the cases of the
Where it is?
page number 7, my lord.
Of
My affidavit in opposition, my lord. Of respondent number 2.
respondent number 2 or 1?
2.
Yes, 1 or 2?
2, my lord.
Respondent number 2 is 1. Repeating, yes. Page.
7, my lord.
Hmm.
Here, my lord. This is the minus of committee for compassionate appointment held on 31st March 2022. In pursuance of police headquarters number so dated 14 October 2019, number so dated 15 October 2019, a board consisting of the following officers held a meeting regarding compassionate appointments. 1, 2, 3 other chairman members. 1. The committee for compassionate appointment decided to hold a meeting once in 3 months to discuss and scrutinize the documents for compassionate appointment and recommend to the DGB. However, due to the COVID-19 pandemic, all such meetings could not be conducted, my lord. After the first meeting on 18/10/2019. Moreover, circular for freezing of all appointments was received from Home Department by Government number so 22/4/2020. The committee meeting was held on 31st March 2020 and discussed about the reply to Shri Mohammed Senior Advocate Gauhati High Court on contempt in RO James in respect of James K. where rear-wise vacancy from the date of petitioner seeking appointment was sought. As such, PSK complied the list chronologically in conformity with the scheme provided in OM number so dated 17 September 9, 2015 and addendum dated 9/4/2019. Number 3. The details of applicants for commissioner appointment prepared as on so as per the date so. The number 4. The committee discussed about the applications forwarded to the government in respect of so accordingly, PHQ submitted proposal to the government requesting for compassionate appointment of the above mentioned applicants, citing that the 2 police officers police officers died in harness while in service. The committee decided to convene the next meeting on August 2022. And the next page is the again subsequent meeting minutes. Meeting minutes of board committee for compassionate appointment held on 12/8/2022. In pursuance to police headquarters number so dated 14 October 2019 and number so dated 15 October 2019, a board consisting of these are the members. As decided in the previous committee meeting, the committee's member had a meeting on 12/8/2022 and decided on the following points. The committee was decided that PHQ will follow the office memorandum issued by the Public and Administrative Reforms Department. However, the upper ceiling of 50 persons for post of commissioner will not be feasible in Group C and D in the police department. The committee discussed and revised the phase 1 application comprising of 247 applicants for commissioner appointment, complied compiled as on 29/3/2022, and which was discussed on the second meeting held on. So details are there. So that is regarding the number two is the number of vacancies, total number of applicants received. This is 247. Number of application not eligible as per PNA-OM is 27. Multiple application for one disease is 7. Number of details of relation with the disease is 3. Number of application under consideration is 210.
Where is the consideration of the petitioner?
My lord, page number 10.
10.
We have, after the meeting, after the board have discussed the meeting, we have come up with the revised compassionate list, which is yet to be finalized, my lord. Here, we have struck out some names which are not eligible, some who are overage and who are not entitled.
What about the petitioner?
The petitioner is at page
Where is the consideration of the petitioner?
65, my lord. It's page number 12, serial number 65.
What does it say?
So his name
This is the list only, but then
my lord, the problem with the department is
from where?
in view of
From
the
this, you cannot show that you have complied with the.
no, we are under active consideration, but in view of the addendum, we are under active consideration. But however, in view of the addendum, which was issued by the government, that the applicants should for appointment on compassionate ground has to be on the basis of the date of death. Not
According to you, since you have worked out whether she's the petitioner is eligible or not.
he is eligible, but there are other applicants whose parents or whose spouse have died earlier to the applicant, to the petitioner. So we
What is the procedure? What is the, it is the date of death or the seniority?
Date of death, my lord, the addendum
By
is
the
at page number
addendum.
6, page number 6 of my affidavit of opposition, my lord, page number 6. This is the addendum, my lord, page number 6. Annexure 1. I've lost, you got it? Governor of Nagaland, Personal and Administrative Reform Department. So it's
Date of death
addendum,
and first
number
preference
so
will be given against those who have died.
the operative portion. Married, my lord. In view of this. So in view of this, we cannot consider his case. That's why the petitioner is before this honorable court challenging this addendum. And then if this addendum goes, we'll consider her case. As per
What was
application.
the earlier, before this, what was the procedure?
Date of application, as per the application.
Date of application.
Now, Lordship, Supreme Court is very clear. Those 3 years above, Lordship will kindly appreciate that it is settled law that applying for compassionate appointment at belated stage of 3 years or more is assumed that the family have alternative resources to tide over and denied appointment. Now, here is a list. This is the list I'm challenging, where 32 years, the father died. And what has happened is, Lordship will kindly clearly see the list. They have included all the names, those who have died in the department and those who have not even applied. Lordship will kindly see the application.
So
To go by the application, I am at student number
you
one.
have not been appointed on contingents also, contingent
No,
basis,
nothing
not
like
consent.
that.
Appoint he or she,
He,
appoint him
Lordship,
in the meantime as a contingency.
no,
The
Lordship,
otherwise, see, this as a matter of right is not. We'll have to go with the policy. Of course, you have put to challenge the addendum, the part of the policy. Now, the core consideration for in such a compassionate appointment is the dire financial situation.
Lordship,
It's not a matter of right as such, but to overcome their financial situation of the family whose breadwinner has died in harness. That is the whole core consideration. Now, if you cannot appoint on regular basis, whatever may be the reason, you appoint him immediately on contingent basis. Otherwise, since 2016, it's nearly 7 years. What's the whole purpose? It gets defeated, hopelessly defeated, your own policy. What's the use of having such a policy
yes, Lordship.
which you, by your action, gets defeated?
My lord,
Abandon, I mean,
yes, my lord, but
do away this policy, then in that case.
this is the policy issued by the government, and then we are the department only. I'm for the department only. So unless the,
See, on the facts of this matter,
yes,
a person died in 2016, immediately applied. The son or whatever, the dependent, on the compassionate appointment. We understand that it's not a matter of right as such. You have the policy. After 7 or 8 years, you are saying, no, we have the different policy, which we have, adopted.
yes,
So you cannot be.
I agree.
The regular appointment is something, are you getting my
Yes,
point?
I'm getting it, madam. Yes.
Otherwise, compassionate appointment as such, it's not matter of right.
Yes, it's not a matter.
It's a compassionate.
Yes.
So if you don't appoint, if you cannot appoint regular basis, at least appoint them to overcome the financial or the destitution. Something you have to do.
Yes. And then
Just
my lord-
keep on, and that process cannot be done. And after 2 years or 3 years or 10 years, you say you are not eligible, you are not under the, falls under the category for compulsory appointment as per this addenda and all. So immediately, and I have not, this court is not satisfied that you have really considered the case of the petitioner. That too, order passed on consent. You have consented, concede. It's a consent kind of order.
Lordship, yes.
So
Absolutely.
you will have to show something, a seriousness.
Yes, my lord. That's why I refer to your lordship to the meeting minutes, and that this honorable court has directed to consider, not to appoint, but we are in the process of consideration. But since
In the
other
process of
applicants-
consideration
Yes.
for rejection,
No.
that
We
is
are
what she is
under
apprehending.
consideration, but there are other applicants also. So as per the addendum,
See,
it has to be
consider
paid of it.
when this court directs, it's a kind of positive direction.
Yes, my lord.
It is not to consider for rejection. Is it consider for appointment?
Yes, my lord. We are considering,
We understand
but there are
the
other applicants
difficulties
also.
of the state also, but then at the same time, when you have your own policy, it has to be abide by.
Lordship, they are saying they are considering the applicants. You just look at their seniority list. Where is other applicants? There is none. And these are all appointed after, I have just to substantiate 3 appointment letters appointed on compassionate ground in 2019. That is,
Is it part of record?
no, Lordship, I just, because before this honorable court, they stated that they have never appointed even one compassionate appointment. That was stated before this honorable court in the previous hearing. Now, in 2019, they have, Lordship, it can be a part with the permission of this honorable court.
Appointment, but then after that is before the court's order.
Lordship.
Is it?
Now, why I'm saying this is, there is no applicant before the petitioner. My
How
lord,
do, madam, in that case, how do we determine who are the applicants, who are not, and how they have?
they have
Because
here,
agent today, there is a violation, but then what they are saying is it is under active consideration. It is yet
But
to finalize because of this addendum.
Yes.
Lordship,
So in that case,
Lordship, I pray that they will consider as per the seniority list that I have been placed at serial number 65. I want this honorable court to look into that matter. Now they have here in their seniority list, they have shown those who have applied, those who have not applied. It is all here in the seniority list that I'm challenging.
this is something kind of disputed question of facts. So we'll then hear you in the writ petition. This court is of the view, taking into the issue, which is a compassionate appointment, which this court understand the core issue is regarding their financial condition of the dependent. So if you can appoint him on contingents for a time being, till the your exercise is over.
Lordship,
Can you?
Lordship, I have one prayer.
Just one last. Because
In that respect, I have to take instructions, my lord, because I have to consider it will be basing on the ability of vacancy.
How's the process here?
Lordship, here,
Process, is it normally we have come across the moment the brother or the father or the who dies, when the application comes, immediately they are appointed on contingent basis. Because
not contingency, Lordship. It's a regular appointment.
no, just wait. Normally. Then in the meantime, the process will take on the basis of the policy of the state. That is regular appointment is made. That is what then at least some succor to the dependent or the applicant
Lord,
will do for a time being.
Lordship,
Lordship, there is one, I
Lordship,
just only pray that one submission.
Yes.
There are other challenges before this honorable board in other writ petitions. They are not appointing not only the petitioner, but no compassionate appointment, no department, 50% dies. They are not giving compassionate appointment and they are appointing just for 1 year. We are challenging, we have filed a writ petition before this honorable board. Forget about the compassionate appointment. They have appointed more than thousands of constables through backdoor. That is the issue here. Why I'm challenging the seniority list, and this seniority list also. I have Supreme Court cases on my side, Lordship, that those who have died 30 years back have applied in 2021 and 22 after the issuance of this addendum. So all those things, is it feasible? And this is happening in all the department. And this honorable court judicial judgment will affect the whole department because this is going on in all the departments. They have collected all the dead data that have died 20, 30 years back, and they have placed all those into, after this addendum, taking advantage of this addendum, they have placed it all in the seniority list. And now, because of this, the petitioner is the only applicant at serial number 1. In 2016, there is none other. And here in the seniority list itself, there is no other application also. It is only in 2021 and 22 that they were applied after the petitioner. The previously application is there. Those who sleep over their right, they will never. And compassionate appointment, mostly it has to be within 3 years, approximately 3 years, Lordship. So how about here? They have listed all those who have appointed 30 years, 8 years above. So all this, I'm challenging this, all this have to go, and it has to be, those who did not apply has been reflected, and I have been kept at serial number 65. Lordship, I pray that after approaching this honorable court, it may not become again so complicated that constable, they are appointing in a year more than 1,000. That is challenged before this honorable court. That is only for 2020.
On compulsory appointment?
No,
Ground.
backdoor.
No. What is the appointments about the constables?
Constables, all these applicants are also praying for constables. They have not appointed, not only myself, Lordship, but this applies to all other compassionate.
But that is not an issue before this court.
Yes,
today.
It's
not.
It will be in the writ petition. Because I'm challenging that addendum as well as this. And if this addendum and this seniority list goes, my case will be covered. And there is no question of contingency appointment in police department there, because if I am to bring to substantiate, I can bring even the appointment orders of LDAs and others. Group C. I have been directed to be appointed in Group C because my education qualification, if so to say, is overqualified, Lordship. So where is the question of, be it in constable post or in any other brevetary post? So many backdoor appointment has been made. Thousands, Lordship, thousands. Even for 1 year, there were 140 constables appointed. That was through RTI, we procured those departments. So it has to clean up, and That, and where is the question of 50%? The arrogance of the respondent in the minutes of their meeting have stated that we cannot give 50%. Where does that kind of arrogance come? When there is an addendum issued by the state. See, these kind of things are happening, Lordship. And all this, those who have applied in 2020-21, after the petitioners, I applied in 2016 to show me at serial number 25, they have shown that I have applied only in 2020. This kind of.
When did you apply?
2016. Lordship,
Come to your page 3 of your writ petition. Paragraph 3. Paragraph 3.
Of my
Writ petition.
Lordship. Paragraph 3. Yes, Lordship.
Just read it.
Yes, Lordship. That the
But-
petitioner is the elder son of
No,
H.
no, one.
Paragraph 3.
After 6th line, the petitioner having requisite qualification.
Yes, 6, 1, 2, 3, 4, 5, 6. Lordship.
Financial constraint,
Yes, Lordship.
the petitioner having.
Requisite
read.
qualification by application dated nil,
Hmm.
applied for appointment on compassionate.
Why you have said so? Application, this will be very crucial.
Yes.
Why you have said nil?
Lordship, I will show my. Because here, page 21, annexure F. But presumably the forwarding letter is at page 22. This is the mistake of all the other, in general, Lordship, they never, applicants, they never give dates. That is the problem with, even in other cases also, Lordship.
Hmm.
So here there is, since there is no date mentioned by the petitioner in his application, I have taken 30th November 2016 is the date when this was forwarded by the Assistant Inspector General of Police Administration, Nagaland, Kohima.
Okay,
To
you have to infer. You have to infer. You have to infer the on the basis of the forwarding letter.
Forwarding letter, Lordship. So, Lordship, not only the petitioner, but this is in a way, others are not before this honorable court, but I am fighting on behalf of all the compassionate applications on humanity ground, Lordship. This cannot go on, and the departments, whichever department, all over Nagaland, is compassionate appointees are.
I can understand, but the merit of your challenge is to the addendum, which is a part of the policy.
Lordship.
That you have to first overcome. If you hear the matter,
Lordship.
number one. Then subsequently, on the basis of documents, subject to what they, counter to
Lordship.
you, rebut it, this is something that is consequential, we may examine. But the issue of challenging the addendum, which is a part of policy, is it a part of policy issued by
Is it a part of the policy?
competent authority?
Lordship. And
On what basis you are challenging it?
when the policy
According
is,
to your addendum, what's wrong in the addendum?
because of this policy, all those who have died 20, 30 years back has been included in the compassionate appointment list in all the departments in Nagaland. That is my case.
Which cannot be, which is
Which cannot be, Lordship.
practically
It cannot.
impossible,
It cannot. And it has to be
practically impermissible.
impermissible, Lordship. So either it has to go by the date of application. Those who sleep over their right, when they don't apply, why should they include it in all the
No,
departments?
inclusion is something different. What this court is of that,
Yes.
the challenge is a part of the policy. You are well aware,
Lordship.
to challenge the policy is not that as we see. On the first blush, we cannot say that this is bad or
Lordship,
this
Lordship,
is good.
Lordship.
So this court wants
But
not
out
to
of-
argue on the legal issue. Why this addendum, a part of policy, that means it's a policy. Bad in law, which this cannot be
Lordship,
allowed to stand.
Lordship.
That is a legal issues which
Legal
this court,
issues.
you have to submit and this
Yes,
court will
Lordship.
determine.
Basing upon the fact. and
But
circumstance.
about this seniority list and all those things, basically it's a compulsory appointment. Unless we find that this addendum is bad,
Of course.
we
Lordship.
cannot go beyond the seniority list and all other things. Because if we find, if this court finds that this is a part of the policy, which is not bad, and it is absolutely perfect, in that situation, we don't have to go into the seniority.
Lordship,
Are you getting?
of course, Lordship.
So first issue would be, you have to come over the hurdles of this impugn addendum. And
Lordship, apart from that, I'll be covered by the Supreme Court cases. Apart from that, this addendum was issued in
2019,
2019.
yes.
At that time, when I have applied, I was covered by the office memorandum.
No,
for completion.
that's another thing, which you may say that it should not be made applicable retrospectively. That issue is something different. But if you are challenging the very outset, I said, this court feels that this
Lordship, even they are
part of
saying
the
that all
policy.
those, even they have submitted before this honorable court that all these seniority lists and all are coming, arises out of the
addendum.
addendum. So when they themselves are admitting, Lordship, and when this addendum is affecting to publish this kind of seniority list, why not, Lordship? Isn't there pick and choose policy? Isn't there discrimination? Isn't there?
Okay, then in that case, I'll hear you. You start your submission. On the petition, will contempt will
Yes, Lordship.
keep aside for a time being.
If my lord.
Or
was
subject to what this court has, that in the meantime, if you can engage him on contingency basis, so as to
Lordship.
not to stifle your own policy. That is another, the view of this court for a time being. But definitely we'll hear today whatever.
I will pray before the honorable court that if this matter is heard, then basing upon the outcome of this repetition, the petitioner's case may be considered. Otherwise, again, if this contingency appointment or this and so, they will take
That's
advantage.
okay. This is just a suggestion of this court. And
Yes,
he
Lord.
for that he wants sometime, that is something different. And if you don't want to have that kind of financial thing,
After 7 years, I don't want Lordship.
any case is forget it.
Lordship.
You ready?
Lordship, I want to say one thing, the constraint of the government also. Now, your Lordship, state has framed the policy for compassionate appointment in 2015. It was following. It
No.
was following.
No,
And
sir,
then it
sir,
was,
sir,
we have produced
Sir,
an addendum,
sir,
2019.
just a
Where is the
minute,
first thing? Where is the
just a
appointment
minute,
notice?
just a minute.
Compassionate appointment.
I just want to have a overview of the matter. I thought this court thought that if you can dispose of the contempt, but then it's not possible. And as submitted by the learned counsel to the petitioner, she wants to argue the matter, so we'll hear you. Let her start, I'll hear you, I'll come back to you. Or do you want some other day? It's up to you, but then
No.
this court is ready to
We
hear.
can hear it, but I just want to address your Lordship to appreciate the stand of the state
Yes,
in relating to the appointment on compassionate. Policy was framed in 2015. It was an addendum was produced in 2019.
yes.
So the petitioner is challenging that very addendum. Addendum speaks about first step first. That means someone who has died
Yes,
first
the court
must be
understands.
considered person. Now, what we do in Nagaland is that compassionate appointments are given to the petitioner as a regular appointment, not in terms of contingency or election. So the consideration that the consideration that your lordship should appreciate the state is that there has to be a clear vacancy to appoint the petitioner. So we cannot simply give an appointment, regular appointment to a person, unless there's a clear vacancy, because appointment that we give is always regular, not contingency, not ad hoc. Always we used to give because of that issue, regular appointment issue. This I think because it was flouted by the applications for compassionate appointment in all the departments of the state. That is why we have framed this policy 2019, citing that the first date should be given first preference and the department. So it was a conscious policy
But
decision.
that should go as per the law.
That is what I am saying. We don't go for contingency appointment to the end commission. We give regular appointment. So that is the issue. So when we say regular appointment,
So
there
let
has to be regular clear vacancy.
then let us forget the contingency.
Yes,
Contingency
but-
appointment,
That is
forget
correct.
it.
Even I'm not interested.
Nobody is interested. And that is not a
No,
law.
the scheme also says so. that
Can the
appointment-
respondent, lordship, the scheme was issued in 2015. Previous scheme was issued.
It's okay, ma'am. Whether you want to start the argument or we'll keep it some other day. I'll just give you an option. If you want to argue the matter, I'm ready. This court is ready.
Lordship, I will argue the case.
Yes.
I,
Then.
with the permission of this honorable court judicious mind. Lordship, let me start at respondent 2. This is subsequent petition again, Lordship. The previous one, and this is the subsequent petition.
Yes.
Starting from paragraph 2. That at the outset, this is the secondary petition of the petitioner in connection with contempt case number so and so arising out of writ petition civil number 21/2020, which is pending before this honorable court. The petitioner is a PU passed in 2013, holds degree in Bachelor of Computer Application, secondary 2016, Drishti Certified Computer Professional Course Certificate in 2015, and postgraduate in ICST Certified Computer Professional in 2019. The petitioner is well qualified to be considered for appointment to any Group C post in concern with his educational and technical qualifications. Lordship, I may just bring my lordship to his qualification is from annexure A, B, C, D till D is his educational qualification.
What this has been. Why this is here? What will the needs to be here? This is the. After this, after the affidavit. This is after the affidavit.
This is the petition.
So the claim number is after the petition.
It's after the, actually they should have. This is the last.
Then why this is here? Unnecessary resource. This is by them. Okay, proceed.
Lordship.
Annexure A, B, and
C and D.
C and D.
Yes.
These are your qualifications.
Yes, Lordship.
Diploma. Okay,
Paragraph 3,
and that certificate is page 20.
page 20. Yes, Lordship.
Yes, there's no dispute
There is no dispute, Lordship.
because died on,
And 21 is the application
yes,
and 22 is the.
died on 28/10/2016.
Yes,
So That certificate is 20 annexed.
Annexure E,
Yes. F is what?
F is
Your application.
my application, Lordship.
Dated nil. Date is nil. Date of the application is nil.
Yes, Lordship.
Okay.
So I will base on forwarding letter that is 30th November 2016.
Page 22.
Yes, Lordship.
Okay.
This is
Please,
This is-
the original receipt from Parliament Secretary. You have applied to the Honorable Parliament Secretary. Huh? Is that it? You have applied to the Honorable Parliament Secretary.
no, Lordship.
Municipal Affairs, Economics and Statistics, Nagaland, page 22.
Page 22.
It is said,
Lordship,
it is said that
here in
a
Nagaland, what hap-
person who seeks equity
who-
must do equity.
Lordship, here, even that appointment on compassionate ground, without the approval of the ministers and MLAs, none can be appointed. This is again another practice
That's what I'm saying. If you practically something different, practice
in practice.
which may not be permissible under the.
Yes, under
If
law.
you are before the court,
Yes, Lordship.
that's why you have to remind that if you are seeking an equity,
Yes,
you
Lordship.
must do equity.
So.
Anyway, yes,
So this is the forwarding letter,
yes. So that is of 30th,
30th November 2016.
2016.
This may be taken as my application, their Lordship.
So immediately on the date,
Yes, Lordship.
28/10 and 30/11, within 2 days.
Yes,
Okay. No, October, no, yes.
October. Within 1 month,
Mm.
Lordship. So
Then
then the office memorandum,
what is the relevant one? Which you are,
office memorandum, annexure G, page 23,
yes, which clause you are relying?
2. Appointment on compassionate grounds shall be given only to one of the following members of this employee's family.
Your
Spouse,
your son,
yes, I am
you are
the
the
son.
son.
Son, daughter only. Now, Lordship, this will cover here in the seniority list. All those nephews, sisters, so and so have been applied. That has been shown
No,
in
no,
the seniority. That will come later on.
Will come later.
Yes,
Let
Lordship.
us see.
Allow me to read out from
Spouse, son or daughter only.
daughter.
Three persons.
Yes. Before
And
there
three
was brothers and
three categories.
yes, before
Yes.
there was brothers and sisters also. But
Okay.
now by this.
This is the one holding the field.
Yes, holding the field till date.
Okay.
Paragraph 3, I will just read out from paragraph 3,
Yes.
Lordship. That the petitioner is the eldest son of Let Kemba Yimchunger, who died in harness on 28/10/16, while serving as Havaldar at B Company Headquarters, Shamatar, due to myocardial infection. The petitioner's father left behind his widowed mother, a housewife, and 5 younger sisters who are studying in colleges and schools. Since the petitioner's late father was the only breadwinner of the family, to tide over the financial constraints.
It's okay, ma'am. You
Yes,
come
sir.
to this page 23, the policy of the state, office memorandum. This close to son, it is
Then 3, paragraph 3, clause 3.
close 3.
Appointment on compassionate grounds shall be made only on a regular basis to direct recruitment post and only if regular vacancies meant for that purpose are available in that department where the deceased government employee was serving.
Yes.
Applicants shall have no claim to appointment under this scheme in any other department other than the department where the deceased employee was serving. However, for the NCS officers, the appointment may be considered under the establishment of the Commissioner Nagaland or the Nagaland Civil Secretariat. 4. Compassionate appointment may be made to the post falling under the combined direct recruitment quota of Group C or D. The ceiling of compassionate appointments of 5% of the direct recruitment vacancies in Group C and D posts has been done away with, provided such appointment do not exceed 50% of the vacancies during a year.
What does it mean?
That means
The ceiling for compassionate appointment.
previously, in the previous scheme, there was 5% lordship. That's why there has to be seniority list. But after this 2015 list, 50%. No, by the grace of God, no one dies 50% in any department lordship.
Okay.
In a yearly regular
So that is
vacancy.
not more than 50%.
Not more than
That means
50%.
50% of the vacancies in a year.
Yes, lordship. In a year,
Suppose in a year, suppose 2023, if there are 3 posts
3 posts,
or 4 posts,
4 posts.
2 will
Two.
be on the for a compassionate appointment.
Then for a police department, yearly, the constables, whatever, they retire, and yearly for 1 year, at least 1,000 post vacancy arises. But
So now it's 50%
50%,
during a year.
yes,
Vacancy of the particular year.
yes.
Okay. Then
So from 20, they have claimed before
Please,
Honorable Court.
please proceed. Then 5.
5. The interseniority of a person appointed under the scheme shall be fixed with reference to their date of appointment. The date of appointment and these are after the appointment lordship. Interpolation with the direct recruits promotees shall be met with reference to their dates of appointment without disturbing the interseniority of the direct recruits promotees. 6. The scheme will be available to family of the deceased employees provided no surviving member of the family holds any regular post in the state government. The benefit of such appointment shall be available to only one family member. The scheme will be applicable only to dependents of deceased government servants appointed and serving on regular basis at the time of death, and will not be applicable to those who were working on daily wage or casual or ad hoc or contract or re-employment / extension / consultant basis. A spouse once appointed under this scheme shall be allowed to continue in service even after remarriage. Appointment made under this scheme shall not be transferable to any other person in any circumstances, and any request for the same shall be invariably rejected. 7. Application under this scheme should be eligible and qualified for the post in all respect under the provisions of the relevant recruitment rules. No relaxation in eligibility will be made in any circumstances. Lordship will kindly appreciate this. No relaxation in eligibility will be made in any circumstances except to the extent provided under this scheme. Date of joining by a person appointed under this scheme shall be treated as the date of his or her regular appointment. All departments shall maintain a waiting list in chronological order. Chronological order means that will be application, date of application, lordship. Otherwise, that date chronological order was never there. So it has to go. The action of the respondent has to go as per this OM. So that shall be maintained a waiting list in chronological order for compassionate appointments. An applicant will be given the waiting list number on receipt of the application if there are no regular posts available. So Lordship will kindly appreciate that that was date of application. Date of application, the applicants will receive a receipt. That means date of application, not by the impugned addendum. Impugned addendum cannot override because this has not been, this OM has not been Lordship rectified, so it cannot overtake this OM, the basis of compassionate appointment. My lord will kindly appreciate that. 8, the upper age limit of applicant. This is also very relevant because there are 40, 50 years old in the seniority list. That's why I'm challenging before this honorable court. The upper age limit of applicant under this scheme may be relaxed in exceptional cases up to a minimum of 5 years. So that will be 40 years, Lordship. Normally, as ST, 35 years is the general rule, but 5 years means that will have to be 40 years. Now in the seniority list, more than 40 years applicants are there. 5 years, in addition to existing relaxation, if any. The lower age limit shall, however, in no case be relaxed between below 18 years of age. Now, Lordship, in the list, those who were born during 8 years, those who were not born, at that time when their parents died, they were 8 years, 10 years, all those have applied in 2021 and 22. That is why I am bringing before this honorable court. So 18 years at the time of application, 18 years of age. So if they have applied in 2022, they are not eligible. Appointment under this scheme, irrespective of appointing authority.
It's okay. You come to 9, 10, last
10.
one.
All departments shall amend their respective service rules, recruitment rules to make a provision for compassionate appointment. Any dispute arising out of the provision of this scheme or any clarification shall be referred to the Department of PNAR for decision of the government. So this is the compassionate appointment scheme. It is regular
So
appointment.
in your case, has the recruitment rule been amended? Any amendment in the recruitment rule? Group C and Group D?
Lordship,
Because
maybe
it
those.
must provide the provision for compassionate appointment in the recruitment rule. Or else it will hit the provision of rules.
Lordship,
Clause
that
10.
is for the state government to.
That will come to them.
That is up to the state government, whether it is their adherence, Lordship. It may not affect the petitioner. So this is the.
No, if you are claiming on the basis of this policy or the office memorandum, it has to be complied in all the clauses. Not pick and tits and bits. This is relevant because, see, government wants to appoint you. But then if rule doesn't permit, if there is existing rules made under the provision 309 or other legislative enactment, then which one would prevail? The rule made under the provision 309 or the enactment by the legislature will prevail over this office memorandum. So unless you have tomorrow this may complicate, not only in your case, in some other cases also. Suppose you have the recruitment rule Group C. You have not amended as per this policy, but you appoint somebody. If somebody, nowadays the constitutional scheme of public employment has to be adhered to. So it has got relevancy, may not be directly affecting you, but it may have a bearing. That, okay, we'll come to the state respondents data in this particular case.
That is.
But since you are considering all the aspects of the matter,
Lordship.
so we'll have to be careful about
I have to
every
take-
pros and cons of the
Lordship,
matter.
Lordship.
Okay. So this amendment has done or not in Group C or D, whether you have a recruitment rule, you'll be ready for that. We'll come back to you later. We'll come to you. Okay, then
Now, I will just, the previous submission before this honorable court by the respondent government. This honorable court asked the respondent government to place the seniority list 4 times.
Okay,
By reprimanding the respondent, but they never placed before this honorable court. Lordship, something is very weird in this case. I have annexed all the orders of the court, reprimanding them to submit seniority list. They
Okay.
never submitted.
Let
And
us- let us see.
Lordship, I will.
Page 25 is
Page 2.
the first order of this court where the contempt has been filed.
Yes, that
Okay.
is 38,
Page 25,
25.
yes. Whereby on consent,
Yes.
this court has directed to consider your case, which
Lordship.
according to them is still under consideration.
Lordship.
Okay. Then,
I is the freezing office memorandum, freezing all fresh appointments. So
Okay.
they have taken this due to pandemic
okay,
and 29, Lordship, allow me to read out.
29,
Yes, Lordship.
okay,
Learned senior government advocate, Mr. Moa Imchen appears for the sole respondent and submits that he has filed affidavit in opposition in the present matter. He also submits that there was difficulty in complying with the court's order dated 8/9/2021, wherein the respondent has been directed to file affidavit showing vacancies that has arisen in the department with effect from 2010-2016 till date. The period from the date when the present petition was filed by the writ petitioner for consideration on appointment on compassionate scheme as contained in OM so and so dated 17/9/2015 and addendum dated 9/4/2019. The learned senior government advocate submits that prior to 2018, Group C and Group D posts were appointed by the respective commandants and SPs in all the district, which is more than 30 appointing authorities. Further, learned senior government advocate submits that the scheme of compassionate appointment for consideration got merged with the access appointment, and hence there is difficulty of effectively accommodating the candidates who come for compassionate appointment in due vacancies that arises. He prayed that the matter may be disposed of with certain directions. I have heard the learned senior government advocate, and it is seen that as per the condition for appointment on compassionate ground, it is provided that 1, all units shall maintain a register for compassionate appointment, and upon receipt of such application, unit commandant shall verify the eligibility criteria and forward it to the DGP. In terms of the above criterion and condition, it is apparent that the office of the respondent number 1 is the sole custodian of the records pertaining to all the appointments on compassionate ground. The petitioner's anxiety and desire to know and be informed of her position of seniority in the waiting list for appointment on compassionate ground has to be satisfied as of right under the RTI Act. The addendum dated 9/4/2019 also clearly spells out that the seniority of the petitioner on compassionate appointment will be maintained in accordance with the record of the death of employee who die in harness. Therefore, I am of the view that the condition and procedures as enumerated by the department clearly suggest that all data are finally submitted to the office of the respondent number 1, who should maintain the seniority and also the data. Respondent number 1 shoulders the responsibility of disseminating the information for proper implementation of the scheme under OM dated 17/9/2015. I am also not convinced with arguments submitted by the learned senior government advocate that the compassionate appointment got merged with the excess appointment that were made prior to 2018. And therefore, the chances of the petitioner who applied for appointment on compassionate scheme gets delayed or are denied. It is clear that there is no legal right for consideration of regularization of the excess appointees made by the state respondent, as it per se illegal appointment without sanction post. It is excess appointment without the authority of law. The state respondent have no legal basis to regularize the service of the excess appointees by taking away the right of the people who come under the scheme, either on compassionate appointment or in other scheme that is in place. It is therefore incumbent upon the state respondent to consider the case of all employees who are covered under the office memorandum dated 17/9/2015, prior to considering the case of the excess appointees who does not have any legal basis. It should not be practiced that illegal appointees should be considered prior to the employees who have some legal right as per rules. If we do so, we are going against the principle of natural justice and also against the constitutional provisions. However, today, learned senior government advocate submits that he will make efforts to bring the details of the petitioners who have come before the authority for consideration of appointment on compassionate ground on the next date. This court is of the view that opportunity should be given to the state respondent to take this one very important step of establishing the right of the candidates who come seeking to the department for appointment on compassionate ground. The petitioner has right to information with respect to the seniority for consideration when vacancy arises for appointment on compassionate ground as per the scheme. The scheme as it stands in 50-50 basis for compassionate appointment and regular appointment. Effort should be made to follow the scheme. Learned senior government advocates shall make an effort to present the list of seniority position for appointment on compassionate scheme and file the same before this honorable court on the next date so that the doubts in the mind of the petitioner are addressed. So this is the first. The annexure K is from the headquarters to the government advocate lordship. I need to read out, lordship.
It's okay.
Then
Yes,
annexure.
they have complied, and then accordingly, as per their compilation, your name is at serial number 50.
50.
So
Then-
page 34 is the list.
At 50.
Okay,
So now, then the next 38, page 38, annexure L.
yes, this is another,
Another order
okay,
that is 11/2/2022.
okay, what does it say?
Mr. Second para
Office
lordship
memorandum submits
submits that a letter dated 30/10/2021 issued by the Office of the Director General of Police, Nagaland, Kohima, including the list of appointment on compassionate ground with effect from May 2019, in which the list, the petitioner's name appears at serial number 50. He has also furnished the letter dated 32/2022, including the office memorandum dated 22/4/2020, and submits that the department is in the process of making consolidated list of compassionate appointment, and the department will initiate the appointment when the ban on appointment is lifted. Mr. Moa shall on the next date file a detailed affidavit projecting all the grounds stated today, along with the annexures and the action taken by the department for appointment of the persons on compassionate ground, more particularly with reference to the petitioner of the present case. This is to be listed on 5/2/2022.
Okay,
Then this is the addendum, impugn addendum that I'm challenging, lordship. that this addendum has to go, especially clause 1. Compassionate appointment for state government employees who die in harness and addendum thereof. In continuation to this Department Office memorandum of even number dated 17 September 2015, the following conditions are added under the compassionate appointment scheme as under. This has to be prospective, Lordship. It cannot, there is nothing mentioned here to be retrospective, and it cannot affect the petitioner, Lordship. 1. Insertion para 2. Compassionate appointment made to group C and D post under the scheme shall be strictly in order of death, and first preference shall always be given against those who have died earlier and who fulfills all eligible criteria. 2. So I am mainly on this 2. Insertion clause 1. Clause 2, that is insertion of para 12, the responsibility of completion of application forms, that is next.
You may be correct that it should be in prospective in effect. But you cannot say that you could not have this policy. If you say, if you could not have this policy, as such, the burden is heavy on you to establish that the state cannot have such a policy.
No, Lordship. I am challenging this, but
that's what I'm saying. You are challenging on which ground you are challenging. That is, you have to make your submission. That is one thing. What I'm saying is, what this court is saying, unless you saw that this is arbitrary, by having this policy, either the state doesn't, it is either arbitrary or the state doesn't have competence to have such a policy, that you have to make an argument.
Only the addendum.
That is one thing, addendum, yes.
Only the addendum.
But if you say, if your submission is that it should be prospective in effect, not in retrospective, in that case, we may consider that is the another part.
Lordship.
So which one you are submitting? Are you saying that the state doesn't have the competence to have such a policy by way of addendum, number one? Or are you saying, though the state has the policy competence, but then it has to have a prospective effect? There are two things.
The state has,
you will have to satisfy.
Lordship, the state has the competence to issue an addendum or any orders, rules and regulation, whatever, Lordship. But this addendum is in violation of Article 14 of the Constitution of India. Because by this addendum, Lordship, the respondent, basing upon this addendum, has resorted to doing illegal things. And that I will show in the seniority list. As per the death of death, as they have mentioned here, they have listed those who have died way back in 1990s, 80s, 90s, 2000, whereas the law is very clear. Compassionate appointment has to be only for those within the time-bound period of 3 years, and at least 3 years, within 3 years. I have the Supreme Court decisions. So when they are basing upon this, isn't this arbitrary, Lordship? Isn't this addendum discrimination? Isn't this violation of Article 14? Isn't this basis of discrimination, pick and choose policy? And why they have appointed, I have placed before this Honorable Court in 2019, they have appointed others on compassionate appointment, whereas the petitioner have applied in 2016. I have, just to substantiate, if my Lord will allow me, I will bring other Group C appointments they have met after 2016.
16.
All those appointments are being made through backdoor. So where do I come? Even in spite of the scheme of compassionate
In the
appointment,
police department,
police department, I have the
on compassionate ground.
not compassionate ground, just backdoor general appointment. So they are not, in fact, they have stated before this honorable court, that is the submission that this 2015 compassionate appointment was adopted. Let the government show before this honorable court, it is 50% how much compassionate appointment they have appointed, and they are making this seniority list. Let them produce before this honorable court. They have admitted it is applied in 2015. How many compassionate appointment basing upon this 2015 OM they have appointed till then? Whereas they have appointed 3,000-4,000 backdoor appointment in police department. That is a scam that is going on in Nagaland. This is my humble submission before the honorable court. If my lord asks me to produce the datas, I will. Because I have even filed application. I have even filed RTI from 2016 till the filing of this writ petition. I have more than thousands of appointment orders with me, appointed through backdoor. So where do this kind of scheme on humanity ground go, Lordship? Until and unless this honorable court pass a stringent order in the interest of not only the petitioner but on a humanity ground for the whole state of Nagaland, Lordship, adopting this scheme is just a farce. And all this, those who have applied in 2019-20 after this addendum is issued just to, for the convenience of those who can list out those who have died 10, 20, 30 years back. And who can list out that, Lordship? It is those who have the nexus. It is those who have the power and authority. That's why this is very serious matter. And this outcome of this case, Lordship, I pray that it will have to rectify the whole system of compassionate appointment. And in my prayers, I have prayed before the honorable court. This is not for my prayer are, I'm asking for question and setting aside impugned addendum bearing number so and so dated 9th April 2019. This is absolutely illegal. Then, and/or I'm giving I'm praying for alternative all and/or. In particular, class 1 of the impugned addendum. That is, it has to be either from the date of application or, Lordship, in order to accommodate and to go by the Supreme Court cases. It has to be within 3 years, approximately within 5 years. So all those who have been entered in the seniority list has to go, Lordship. They have not even applied. They are just trying to take advantage of this addendum. They have entered the name who have applied. And if to go by application, only the petitioner number 1 is the first adjournment number 1. But those who have applied in 2021 or 22, after this addendum, they are void because their parents or their brothers or sisters have died 20, 30 years back. How can an immediate relief scheme for financial difficulties be applied after 30 or 40 years? Those who have not been born has been entered in this seniority list. That's why I'm challenging the seniority list. It has to go. And this addendum is the root cause of having all these illegalities committed by those who are in power, Lordship. It has to be appreciated by this honorable court. This is on a humanity ground. So my prayer is, I have asked the direction, Lordship, before this honorable court, direct the respondents to issue fresh notification declaring date of application as the determining factor for giving preference in appointment on compassionate ground, and/or amend, rectify the impugned addendum dated 34/2019, in particular, class 1, by making date of application as the determining factor for giving preference in appointment on compassionate ground in consonance with immediate relief measure. B, to make fresh compassionate appointment application list. E, give specific time frame to make application for appointment on compassionate ground as per the scheme. That I will leave to my lordship's diligence, that whether it has to be from the date of receiving application, because those who sleep over the right, they have a right, but they did not apply. There were other prior scheme also before the Honorable Court. They did not apply even under the scheme. And now after this addendum in 2021, they are coming after 30 years. Because of this addendum, that's why I'm challenging this addendum that is bringing discrimination, pick and choose policy, and those who are in power has the power to manipulate the seniority list of compassionate appointment list, not only in the police department, but in all the department are facing this. Recently, in some department, 25 compassionate appointees were issued. Therein, lordship, those head of the department, families, those who have died 20-30 years back were given first preference to even those who have approached this Honorable Court and the court direction to be considered within 2 or 3 months. See, this kind of things are happening. I did not produce this before the Honorable Court because it is pertaining to police department. It has enough proof and evidence before the Honorable Court that exploiting, manipulating this office OM, the whole department has manipulated the compassionate appointment list. That's why immediate financial relief has gone to 4, 5, 6, 7, 8, even 10 years. Look at those who have applied. They said in 2015 they have applied, but look at those who have applied even 10 years back. Those who have applied. I will come back to my prayer. That is.
See, madam, whether you are able to properly communicate or not, what this court's query, that see, just declaring, do you have the policy, wrong or right? You have to show the policy is bad, or else in the competency of the policy, having the policy. Now, if policy is there, if the authorities are misusing it or misinterpreting it to their advantage, that cannot be a ground for setting aside the policy as such. Correct. So just setting aside the policy.
I'm not asking for the policy of 2015.
No, this is a part of policy. This is also a policy. Its addendum is a part of policy. It is also policy. What is there is that the date of death is to be should be considered for seniority, to count the seniority. The basis is the date of death. So if this is misused by misinterpreting, it's not it. There is a whole another issue which court can examine. But
I am on that logic.
Then that can be examined on the basis of the materials. But simply directing, seeking to set aside the policy is not that easy. So you have to convince this court
Lordship, in my
why this addendum is bad, that you have to convince this court to set aside. Because the court has also, you are well aware, the limitations also. The policy is the domain of the
addendum,
executive.
If this addendum, as per clause 1,
Yes.
as per clause 1, the respondent.
What was earlier? What was the before this addendum? What was the basis?
Application.
Yeah.
Application, Lordship.
Was it a part of that, was it incorporated in that, this thing?
It
2015
has
policy?
not been mentioned, but from the date of.
That was
receipt
the
of
practice.
Application, yes.
It was
that
not
was it.
specifically stipulated,
Yes,
not specifically, it was not.
no, there was no specification, even here, no specification.
But the
Why-
practice is from the date of application. Now by this addendum, it is the date of
Date
that.
of death.
Okay,
So if my lord does not want to set aside this addendum, I'm.
no, I have not decided, it's just I'm
No,
hearing
Lordship,
you.
anyway.
I'm now hearing you.
In the interest of, in the interest, Lordship, only the clause one.
Close one.
Clause one. Let there be date of application or within. Application can be as per the Supreme Court, as per the Supreme Court.
No, that I understand, but there is another Supreme Court judgment, or the law is very clear. Just because according to the court or according to the petitioner, policy is not suitable to him.
No,
Or
it is not
there-
suitable to
there-
whole compassionate,
no, there
not
could
only
be-
the petitioner.
There could be another policy. We cannot substitute the domain, which is exclusively for the state or the executive.
Lordship,
That area has to be looked into also.
Lordship.
So that's why from very
No,
beginning, this code is wants you to argue why this is bad. I understood why this has been misinterpreted, why this has been put to advantages to those
Compassionate.
higher ups or whatever. Misinterpretation or misusing, taking undue advantage of the policy is something different. But to hold a policy by the court is bad or impermissible.
Lordship,
of a particular policy.
Which has discriminated, which has.
That's what I'm saying. You saw that you make that submission only.
Lordship, basing upon this, my lord will kindly come to page 44.
Yes. Yes,
If not because of this addendum,
yes,
this would not have happened. This is what I'm saying, Lordship, before
Yes.
this honorable court.
yes,
Look at the first serial number 1,
yes,
died on 16/8/1991.
yes,
Now they are 38 years.
yes,
They are showing at serial number 1.
yes. Date of birth,
1991.
okay.
What I'm saying
Date of
is,
expired 1991.
so at the time when the father died, the petitioner was, the applicant was born. Is that feasible, Lordship? He was 4 months old. Is that feasible to show in the seniority list? To deny the petitioner the appointment? This is what, and this is the proof and evidence that the addendum is illegal. That's why,
According to you,
Lordship, according to law. According to law,
according to law, as per your understanding of the law.
Lordship.
This we can understand.
Then I have written all the years.
Okay.
32 years, 25 years, 21 years, 18 years, 16 years, till the last is 7 years. And even the 7 years, the Supreme Court is very clear. Those who have approached, or those who have applied after.
So by this seniority list, you are at serial number 66,
66,
which may not be possible
which is not possible.
at all.
Because, and Lordship will kindly see the qualification. None of. Then date of application received, they have included here. How many applications have been received? The last second date of received, that is application, Lordship.
Okay.
Post applied for is the last column. Then
Date of receipt is a date of
the receipt of application by the department, by the respondents. So 1991, they have not applied. This is died in 1995 after 25 years, applied on 17/1/2022. That's why I'm saying all these are illegal. How can those who died in 25 years back, whose parents have died 25 years back, apply in 2022? This is the cause of action arose illegally because of the addendum. This is what I'm trying to impress my lordship before this honorable court. Lordship, I will also.
I have understood. This court has understood
Lordship.
what you are submitting.
And
what
if
this
any
court-
administrative orders or action that is against the constitutional scheme, Article 14, isn't that, Lordship, isn't that illegal before this honorable court to be questioned, set aside? Then serial number 3, Lordship. Serial number 3. Date of birth is 2000. My lord has seen serial number 3.
Yes.
I want to impress this honorable court, all the illegalities that is apparent on the face of record before this honorable court. It cannot, this kind of things, this kind of actions of the respondent cannot stand the test of law, Lordship.
3, there is no application.
No application, no application. See, 3 has no application. Date of birth, this is 2000. Then father died in 1996. Date of birth is 2000. Serial number 3, daughter. I beg your pardon, Lordship. Serial number 2 is sister. This sister is no more in existence.
As per the
scheme.
only the spouse,
Sons and daughters.
daughter.
Yes, Lordship.
Sister is no longer there.
Yes. So in order to shift me to serial number 66, look at the illegalities, Lordship, and this cannot continue. Then father died in 1996.
So and so forth.
So and so for all this, still the Lordship.
Have you given all this thing in your petition?
Of course, Lordship.
Which paragraph?
Lordship, kindly come to my paragraph. Instead of
This detailing which you have submitted. Yeah.
Lordship, kindly allow me to read out that
Para 9.
para 9, yes.
Okay, I've seen it. It's okay.
At least let me read out.
It's okay.
By my lord, because
No, I've seen it.
it is very absurd. In fact, Lordship.
This court will quote this.
Lordship,
Whether in
it's
your favor, in your against you, against the petitioner or favor.
yes,
I'll quote it.
Lordship.
I'll quote it.
It is unfortunate. And this kind of things are happening not only in this.
Because this addendum gives a handle to
finish
resort to
exploitation, Lordship.
all this exploitation.
Yes,
and,
Lordship. Very much against Article 14 and Article 16, Lordship. These are apparent on the face of report.
I think most probably the state might have filed a detailed affidavit against this petition.
Lordship, police department is only one.
No, I'll come back to you. Let her complete. Just wait. Just wait. Wait for your turn.
Police department is the only department that commits such illegal things.
Don't the states
Lord,
your learned friends words. Let him.
as I have said, even after 2015, forgetting about previous, there was 5% quota, Lordship. Subsequent to this, prior. After doing away with that, now 50%. In no department in a year, at least there will be 10-20 vacancies. Police department, 2019 and 20, it has 1,140 backdoor appointments. 500, more than 500 did in the police department did 500 and more died. Lordship, those are the the
I think you're almost,
I will just go with the.
you just give the judgment. And
Yes,
the
Lordship.
judgment, what is the
Lordship. My
I
lord,
think you have completed, more or less.
more or less, my lord. has
No, you,
already
no,
under-
you have shown that the
Very much.
addendum and the seniority list, and you have shown the paragraph 9 and all.
Very much. Very much.
So I think,
Paragraph 9 is very relevant, Lordship. And Lordship, my prayer, I'm not, if not setting aside, amend, rectify the impugned addendum dated in particular clause 1 by making that of application as the determining factor for giving preference in appointment on compassionate ground in consonant with immediate relief measures. The respondent also should not carry on this more than 10 years to appoint compassionate appointment that is against immediate measure relief. Then D is to make fresh compassionate appointment application list. E is give specific time frame to make applications for appointment on compassionate ground as per the scheme. That will be based on the Supreme Court case, Lordship. D, this is also very important, Lordship, in the interest of the whole department, whole state is before this Honorable Court, Lordship. Strictly follow 50% limit of vacancies arising in a year for compassionate appointment as provided under the scheme dated 17/9/2015. Lordship, I'm just seeking that rectification of the addendum or set and quash aside so that they can fix afresh the limitation of application year as per the law of the land, Lordship. I will come to 2011-13 SCC.
how many cases you have?
12, 13, 14, paragraph 12, 13, 14.
Page.
Yes, pages, Lordship, 42. Is this? Yes, 42.
42.
42. 41, Lordship.
Page
2011-13 SCC, page 41,
No.
paragraph
41 is different. This is Godavarman Tirumulupet,
right?
pollution and environment. Where all
This is
the,
42, 42, Lordship.
yes, 42.
Yes. Allow me to read out from paragraph 12. This is with regard to application. Why all those applicants have to go and petitioner has to be adjourned number 1. 12. Ideally, the appointment on compassionate basis should be made without any loss of time but having regard to the delays in the administrative process and several other relevant factors such as the number of already pending claims under the scheme and availability of vacancies, etc. Normally, the appointment may come after several months, Lordship, or even after 2 or 3 years. It is not our intent, nor is it possible to lay down a rigid time limit within which appointment on compassionate ground must be made. But what needs to be emphasized is that such an appointment must have some bearing on the object of the scheme. 13. In this case, the respondent was only 11 years old at the time of the death of his father. The first application for his appointment was made on 2/7/1993, even while he was a minor. Another application was made on his behalf on attaining majority after 7 years and 6 months of his father's death. In such case, the appointment cannot be said to subserve the basic object and purpose of the scheme. It would rather appear that on attaining majority, he staked his claim on the basis that his father was an employee of the municipality and he had died while in service.
This is against the, apart from principle of law. general principle of law. This case is against those who have been appointed after 10 years or delay after seeking for an appointment. After,
Yes,
lapse of,
belated stage.
in a belated stage.
Yes, Lordship. 14.
So nobody is before this court who have been appointed after long lapse of time. I agree with para 12. There's 13, 14.
Yes.
It can aid to a situation where the person have been appointed after delay of say 5 years, 10 years,
Yes, very
which
much.
according to the scheme, by the time the person gets tied over the financial situation,
Lordship.
which the scheme came to its aid. Is not it? Okay,
Lordship,
I'm understood.
14 will say.
Yes, 14.
In the fact of the case.
Yes, yes. That's what I'm saying, in the facts of the case.
Lordship.
14, don't rely 14. Because it's in the facts of that case.
Lordship.
You realize para 12 only.
Then. Lordship will kindly come to
How many cases do you have? Rely
5 only.
only 5.
Only 5, Lordship. Paragraph. 15 to 17, 2006. Lordship, I will just come and read out only the distance, other half.
Huh?
It is already break time.
It's 1. Okay. We have consumed the entire day. Depriving other your colleagues.
Maybe this lordship, my lord, if I may be allowed to make a mention. My lord, item number 8, if this can be listed after vacation.
Item 8 on the prayer of so-and-so. This matter after vacation.
Obligation, lord.
Lordship, I beg your lordship indulgence, item 53.
53.
Yes. In this manner listed of the vacation.
53 after vacation. Otherwise, you are ready.
Yes, lordship.
You are ready.
The problem is, lordship, I have
So,
a matter according to
MS Judge Zimomi has deprived all her colleagues and forced them to venture into the adjournment prayers. After vacation, 53.
Lordship, your lordship, I beg to mention item number 35 and 36.
35,
That
36
come up after the vacation.
after vacation. Well,
Here, what here? So sorry. I have to keep on waiting. I have to keep on waiting. It's going to really force my heart to go into this. So, that's This is last year. Three months. 4 years, 8 months, 8 months.
May I please, Your Lordship?
Yes.
Your Lordship, I would like to mention orders 41.
Order, we'll see.
Item number 41, 41. Your Lordship, in this matter, the appellant insurance company, they have deposited the 50% of the awarded amount. So the claimant may be allowed to withdraw, Your Lordship.
Have you filed the?
Yes, I have filed.
We'll see then. 41,
Yes, Your Lordship.
40 and 41.
No,
We'll
41.
we'll see. Wait for that.
Please, Your Lordship. I beg to mention item 32,
32 is what?
anticipatory bail application.
Yes.
So currently this matter will be listed after the vacation. And also there's a similar matter here connected with this. Anticipatory bail number 27, which has not been listed today.
Item
So-
32.
Yeah, 32, Your Lordship.
You are in favor of your interim order. Is there interim order?
Yes, Your Lordship.
That's why.
And there's another matter, similar matter, which has not been clubbed along with this
On the
matter.
prayer of Mr. Swain's learned counsel for the petition, list this matter after summer vacation, along with
Anticipatory bill number
AB
27.
number 27 of
2023.
2023.
Much obliged, Your Lordship.
List after summer vacation.
Lordship 2006, volume 5,
Yes.
SCC, page 772.
772.
Yes, Lordship,
Para-
paragraph 15 and 17.
15.
I have just cut down 15, 17 and 18, Lordship. I've just cut down all the paragraphs. 15 says, in Sushma Gohain versus Union of India, it was observed that in the claim of appointment on compassionate ground, there should be no delay in appointment. The purpose of providing appointment on compassionate ground is to mitigate the hardship due to death of the breadwinner in the family. Such appointment should therefore be provided immediately to redeem the family in distress. 17. In the case on hand, the father of the
It's okay.
applicant died.
All certain position.
Yes. After applying 4.5 years,
Hmm.
it was, appointment was denied.
Yes.
Two 2002, volume 10, SCC,
Yes.
7 and 8.
7,
7 and 8, Lordship. Page
708.
Page is 246, Lordship,
Okay.
and paragraph is 7 and 8. I'm sorry, I beg your
246.
pardon, Lordship.
7 and 8.
Yes, Lordship. As the application for employment of her son on compassionate ground was made by the respondent after 8 years of death of her husband, we are of the opinion that it is not to meet the immediate financial need of the family. The High Court did not consider the position of the law and allowed the writ petition relying on the earlier decisions of the High Court. 8. In view of the above settled position of law as the application was filed after 8 years of death of her husband.
Yes.
And this is, I'm just referring this as per the settled post, I beg your pardon, Lordship. This is 2022, volume 2, page 157,
SCC.
SCC, Lordship.
Para
Para 5,
para 5.
para 5, 6.
Hmm.
6 and 10. This is with regard to clause 7. This is printing the clause 7 of the compassionate appointment scheme.
Yes, that is what I am trying to say.
Yeah. As per the settled proposition of law laid by the.
Instead of setting it aside, the addendum,
Yes.
you can direct it as that of the recruitment rule, the amended rule, which cannot be allowed to be regulated
Mm.
for the purpose of appointment or promotion when the vacancy was, I mean, not filled up at that point of before the unamended rules.
Yes.
That same corollary will
Yes.
apply.
That is, a proposition of law is that Lordship appointment on compassionate ground, the policy prevalent at the time of death of the deceased employee only is required to be considered and not the subsequent policy. So what I'm trying to impress upon my honorable board is that here in the compassionate OM, it says, clause 7 says, an applicant will be given the waiting list number on receipt of the application. That means at this relevant point of time when the petitioner father died, this
No,
OM
that's
was-
right. In this particular your case, this addendum cannot be made
Yes,
applicable.
Lordship.
That is one point of looking
one
at it.
point of view and to.
Because I reiterate, it's very difficult. Easily, we should not interfere the policy decision or the policy of the state unless it is so warrant. It may have a, because there was no, the policy of 2015 was not that clear about the basis of the seniority. So so something like from date of, we can infer that is that from the date of application. But this addendum clarifies, but it should not be made retrospective in your case.
Lordship, I just humbly pray before the honorable court that it's not a PIL, but this is this one is the.
No, anyway, I have heard you will consider that aspect also, but then what I was pointing is that without interfering.
I will
Yes.
read out this, Lordship. I have this. I have citations.
Verify when?
2013.
No, this one.
Oh, this one.
5 and 6.
Five, 6, and 10, Lordship.
5, 6 and 10.
Yes. This is 2013, volume 16, SCC. Page is 293, Lordship.
293.
Paragraph 24 and 25. This is for what my lordship was asking me to enlighten. This is Para 24 and 25. 2013, 16 SCC. Oh, lordship, I'll just read out.
Just read.
This has not been placed for the matter can be looked. The matter can be looked into from another angle as well. In those cases where courts are concerned with the judicial review of the administrative action, the parameters within this administrative action can be reviewed by the courts as well settled. No doubt, the scope of judicial review is limited and the court do not go into merit of the decision taken by the administrative authorities, but are concerned with the decision-making process. Interference with the order of the administrative authority is permissible when it is found to be irrational, unreasonable, or there is procedural impropriety. However, where reasonable conduct is expected, the criterion of reasonableness is not subjective but objective, albeit the onus of establishment of unreasonableness rests on the person challenging the validity of the act. It is also right that while exercising limited power of judicial review on the ground mentioned above, the court can examine whether administrative decision in exercise of powers, even if conferred in subjective terms, are met in good faith and on relevant considerations. The court could inquire whether a reasonable man would have come to the decision in question without misdirecting himself on the law or fact in the material aspect. 25. The decision of the administrative authority must be related to the purpose of the enabling provisions of the rules or statutes, as the case may be. If they are manifest unjust or outrageous or directed to an unauthorized end, such decision can be set aside as arbitrary and unreasonable. Likewise, when action taken in ultra-vires, such action decision has no legal basis and can be set aside on that ground. When there are rules framed delineating the powers of the authority as well as the procedure to be followed, while exercising those powers, the authority has to act within the limits defined by those rules. A repository of power acts ultra-vires either when he acts in excess of his power in the narrow sense, or when he abuses his power by acting in good faith or for an inadmissible purpose or on irrelevant ground or without regard to relevant consideration or with gross unreasonableness. This was to explain in Sri Sitaram Sagar Company Limited versus Union of India in the following manner. Lordship, here what I'm trying to impress upon this honorable court is that, especially basing upon the addendum, that is the root cause of all the department's corruption in this compassionate appointment case, and it has to go, Lordship, because in no way, in none of the Supreme Court cases, in no department, there has been any addendum or OM or so in any of the Supreme Court cases where seniority listed has to be done in such a manner. That has not been pronounced by any of the court, and it has to be in a reasonable manner.
Therefore, you cannot rely on that.
Lordship. So we better rely on that. How can?
No, therefore, we cannot rely on that. Because not a single decision of the Supreme Court involved the addendum where it prescribed the date of death.
Because that is never prescribed even in the central government compassionate appointment scheme. When the central scheme has no such seniority list of pertaining to compassionate appointment, how can this addendum give?
That's what I'm saying. Are you saying the competency of the state to have this policy? Are you on that? When you say that central government doesn't have that, and nowhere it doesn't prescribe for the basis, base should be of date of death. In that case, are you submitting that state doesn't have the authority or
Authority
competence to
prescribe
have
the
this?
seniority basing upon
This is what you are
that,
saying.
that. So that is why 40 years have come inside in all the departments, Lord.
So that is
So
another-
basing upon the Supreme Court, even I have given the citation that for some months, 4 years and some months application.
No, you have a point that just because of this addenda, you
Yes,
started receiving the application
yes, Lordship.
in after 10 years, 15
After
years, that
30
you
years.
have the point.
32 years.
Yes, you have the point.
So this
But-
addendum is the.
But other submission which you have said that this addenda cannot be allowed to stand,
Yes.
that is something which you will need to have a deeper.
Lordship, I just humbly pray that if my Lord wants some other decision more than this, at least allow me to give the second, because today, since I was very much based on the seniority list, showing apparently the widespread corruption.
No, that I agreed. This
That's
court is almost convinced. Of course, I have not heard the state council, but then it's prima facie, there is something is wrong on the seniority list and all based on this. But the questioning the addendum, that it's goes to the root of the competency of the state, whether the state has the competence to have this policy or not. That is first thing. Second thing, you will have to show
Any
that
state
though the
action-
state has the competence to have this policy, and they have the prerogative, whatever, but then the policy itself is so arbitrary that it cannot be.
Implemented.
Yes, that is what you have to
Yes, Lordship.
argue on that.
Lordship, as I was saying, I was just basing upon the records before this honorable court. I did not go into that much extent.
But
So,
because
I-
this is more important than this. This court has already observed that on its facts, the actions based on maybe a undue advantage or a misinterpretation, that is another aspect which we have prima facie found that this is something wrong. As per the seniority list is concerned, based on this addenda. That part is something misinterpretation, undue advantage or I was not use the word manipulation as such, but it's an action which you are supposed to, initiate. It's not been done as per this. That is one thing which we will consider and we are considering. But first thing, this is the one which this court wants that you should make a submission.
Which is just,
Because this is more important than the consequential thing.
if not the question aside the addendum, just that clause one. Clause one, if my lord will interfere with that clause one, and they bring up another a specification as to be it from the date of death within the years.
Madam, that is the whole problem. So we'll have to examine. The judicial review, it's limited. But then there's no bar that you cannot look into it.
Lord.
While looking into it, considering it, whether we can interfere or not on the policy, that is more important. There's no quarrel that there's a judicial review lies on the policy also, but policy as such, interference is very limited. So you have to satisfy this call. Of course, you are doing it and you have done it to persuade this court to interfere. But this court wants that you should put more effort. You should make more submission because this court finds goes to the root of the policy.
In that case, Lordship, allow me to submit Supreme Court more citations by tomorrow. By tomorrow, that is, this may be the case may be Lordship will whether.
No, we'll finish it today and we'll.
That's why, even after that, I can submit a citation to
Yes, yes.
satisfy my lordship.
Yes, yes.
Because this, if this stands or if there be any inclination towards this, it will again be the same. Because this is a widespread.
You are more interested in not the job, you are more interested in setting aside this addendum.
Yes, Lordship, this is killing two birds with one stone. In fact, Lordship, because.
But we don't believe.
So this is it. So that will suffice. I will submit citations. Allow me to submit.
You believe in killing two birds by one stone.
Yes, one is for the.
We believe one stone, one bird, not two birds.
One is for the petitioner before this honorable court, basing upon the petitioner's grievances. If this death of list, there be some specific time bound period that will be okay, reasonable. That is as per the Supreme Court, judgment. But if this is made to stay, then the same thing will happen, and the whole department corruption arises out of this, Lordship.
That is somewhere that remedy will lie somewhere in different proceedings, subsequent or the other proceedings. Of course, you have touches it, would have a ramification or the amplification.
Yes, Lordship.
Ramification or amplification, either of the two. But then we'll have to determine on the facts of
implication by this addendum clause 1 has negative ramification in all the general department. So it is interconnected.
So therefore, that will have a different proceedings. That will lie in the other proceedings, lies somewhere in other proceedings.
Other proceeding, Lordship. When an irregularity, when there is a vast corruption, say like passing upon this, and since this is this clause 1 pertains to whole state of Nagaland, Lordship, be it positive or negative, it will have the whole state implication.
That's why. That's the reason. When it has the implication or the ramification, will have to be either as a lawyer or as a court has to be very careful. We should not just slip short by in the name of disposal. We should not go by that. So this appears to be a small matter, addendum, which provides for that death, but it will have a ramification. So we'll have to properly determine it.
The connection is within the specific time-bound period. Even those whose parents have died in harness, if the applicant have no interest, lies upon the right to apply it after 10 or 20 or 30
That's
years.
what I'm saying. I've understood. I've understood your point. That is the consequences which they are misinterpreting it, misusing it on whims and fancies, allowing the persons to apply after 30 years, 20 years, 10 years. But that could not be the intention of the policy by this addendum. It could be, suppose it is in 2019. From that onwards, if application is there, then only in that case, it may have the effect.
Yes.
In that case, nothing will have a problem for, I mean, it has to be equally applied to all who is entitled, not only one person or two persons.
Of course, Lordship.
Now,
so those who have applied.
Your case is why this appears to be illegal, this addendum, because they are misusing it. Your case is 2016. They have an addendum which makes your case applicable. And at the same time, allowing these other candidates whose fathers and has unfortunately died 30 years back, 10 years, 20 years back, which could not have been allowed by application of this addendum.
Lordship.
This addendum
Cannot be applied.
Cannot be applied.
Lordship.
But after the addendum, It could have been applied. Suppose 2019. After this addendum, if somebody files thereafter an application, that could be a reasonable one.
Yes, Lordship,
That you have filed this application on this, and suppose 2 persons died in the same area in a month. Then how do you at the same time application is in the same day, on the same day?
That's why. Lordship,
Hypothetically, then in that case, is it not reasonable to have that kind of parameters or base that the seniority will be the application or considered on the basis of seniority of the date of the death?
Yes, that's why we didn't. Yes, yes,
that is
Lordship.
reasonable. But in your case, which you have projected,
Lordship.
by applying this addendum,
Yes.
you have been made junior, whereby along these other parties, the many persons to apply, even after
Application can be made
10 years.
in a specific time bound period. That's why that is what I'm asking for, Lordship.
Hmm.
Not that 30, 40 years, but basing upon that, the date of birth, date of expiry can be
No,
considered.
in that case, though that specific date, I mean, the time is not been specified.
There has
By
to be
enunciation of the Supreme Court,
Yes, yes,
it says there should not be delay, because
There's
it defeats the whole purpose of your scheme.
Lordship.
It is for dire financial hardship or the situation of the family, defended family.
The central government has issued notification on the compassionate appointment scheme, and that is within the limit of 5 years application.
In that case, the government can, but court cannot direct that you adopt the same thing.
That is there, but the
The
Lordship, reasonable.
wisdom should prevail on the government.
Reasonable time.
So this court, prima facie, has seen it that if this addendum is applied, which was meant to be in a proper perspective,
Yes, Lordship.
I don't see, this court doesn't see any wrong in this. But if you applied it wrongly, by taking undue advantage on the or by the some officials and officers by on their own whims and fancies, that particular case we can take into we can consider it. That is what exactly your case is. I don't know exactly what is the seniority, what is not the seniority. By this impugned seniority, it is prima facie, this court finds that this is wrong, this cannot be allowed, because the very basis of the scheme gets defeated
Yes, yes.
when
that
you
is-
apply this.
That is it, that is it.
But
So,
the addendum as such, it's not, it appears to be not bad,
Lordship,
because it doesn't provide
Lordship.
the clearly that it should be from the date of application or from the date of death, to base the seniority. Somewhere something has to be
Yes.
prescribed.
yes.
So according to this court, prima facie, as such, this addendum appears to be not that arbitrary or bad, but the application
Application
of
is bad.
applied by the
Respondent.
respondents,
Yes, Lordship.
it cannot be accepted. That
Lordship,
is what I
Lordship,
prima facie
exactly,
find.
Exactly, that is also my concern.
So
there
that
has
is
to be
on
a-
that context only.
Yes,
Otherwise,
yes.
you may be right in saying that if these things are allowed
Lordship,
to go on by upholding the interpretation application of the addendum,
yes, Lordship.
this will have an effect on the
Restrict.
deserving candidates
Yes, yes.
and all over the state. That may be correct. But the proper application in a given facts and circumstances, you can interfere.
Yes, Lordship. Because.
Not the entire the
Yes.
addendum, which this court finds it a policy decision.
It will push back the applicants to 10, 15
That
years.
we can understand the
Yes,
facts of this.
my lord
matter.
has exactly
Ah.
understood the point. Obliged so much, Lordship. Now, I'm so sorry that I got only this. This is police, Nagaland Police Manual, where with regard to appointment, they have stated in Manual 5.
Hmm.
5.
Which this court has recorded in one of the order.
that I'm not,
No, you have read one
that will
order.
not have been recorded.
No, no,
Lordship.
you have read one order where this court has mentioned about that procedure.
Not in there, Lordship. I will just show my Lordship, but I'll just read out.
Hmm.
In making, that is subclause 2, in making appointment. This is for the police department.
Okay,
No service rule and such, but this is the manual where it says, subclause 2 says, in making appointment, relevant government order with regards to reservation of posts should be strictly adhered to. So that will mean 50% compassionate appointment. That is also covered, Lordship. They are not adhering, they are in contradiction to their own manual.
okay.
This- Why?
You are insisting that it should be 50%.
Yes, Lordship, that is a direction should be given that since there is a scheme providing not to exceed more than 50%, this 50% should be implemented in toto. Subclause 2, Lordship.
So close to making appointment.
Yes, Lordship. That will mean they have to implement 50%. And if we are to count all the backlogs, compassionate appointment will amount to more than thousands of posts, if to go by how appointment has been made.
Is it about the compulsory appointment or general?
In general, Lordship.
So this will covers the policy,
Policy,
the state policy of
Lordship.
2000 scheme.
Yes, Lordship.
It covers the
exactly.
scheme also.
Exactly. So 50% they are not implementing. Since 2015, how many appointments they have made? Thousands and thousands. But they are not taking up compassionate appointments.
Okay.
Lordship, I will. Obligation.
Yes, your lordship. Your lordship is well aware that the mandamus, for the right of the mandamus, under Article 226 of the Constitution, your lordship, there has to be a infringement of enforceable legal right of the petitioner. So by challenging this addendum, where is the enforceable right of the petitioner? That is my number one question, because this addendum covers the 82 odd departments in the state. Amongst the police department is only one. We have 82 departments in the state.
Okay.
So for the sake of one department, how the entire addendum, which is agreed by the other department, can be thrown out. That is my main condition. And so far as your lordship, the insertion of the addendum has been concerned. 2019 has been concerned. It has been done following the due process. So now, following this Article 166 of the Constitution, state government has framed a policy for your lordship, the Nagaland rules of the executive business. So basing on that, the notification was issued in the name of the governor. So, and relate to the framing of the addendum, there is absolutely no wrong policy decision, your lordship. Your lordship may kindly come to the counter affidavit file on behalf of the state respondent 1 and 2, that is Chief Secretary on Home Commissioner, your lordship.
1 and 2.
Filed on behalf of state respondent 1 and 2.
Yes.
The Chief Secretary of the State and the Home Commissioner, your
Which
lordship.
date? That is 27 June 2023.
27/6.
When it was filed? 27 June.
Yes,
Is it
yes, this one.
2027 June?
Affidavit in
2000
opposition filed for and out of on behalf of respondent number 1 and 2, your lordship.
Yes, Abhijit Sinha.
Yes.
Okay. Please.
Your lordship may kindly come to the preliminary objections. Come to the preliminary objections raised for the maintainability of the petition. May I read it, your lordship?
Yes.
4.1, your lordship.
Yes.
By filing this writ petition, the petitioner is challenging the validity and legality of OIM dated 17/9/2015. That is the parent one, your lordship. With addendum dated 19/4/2019. Revised commissioned appointment scheme for state of Nagaland employees who die in harness. We are in by addendum 19/4/2019. It was categorically stated that the commissioned appointment must be made to Group C and D both under the scheme shall be strictly in order of date of death, and first preference shall always be given to those who have died earlier and who fulfills other eligibility criteria. 4.2, your lordship, that the answering deponent respectfully states that the present petition is filed by the petitioner wherein the commissioned applicants list dated 23/2022 was published. Your lordship, it is stated that the petitioner name was listed as serial 65. It is understandable that the challenge which is being made in the petition in regard to the addendum dated 19/4/2019 is apparently with the sole reason in regard to the placement of the petitioner in the serial order. As per addendum dated 19/4/2019. As such, there is no infringement of fundamental rights or other enforceable rights of the petitioner. Lordship, when petitioner came to know that he is placed as serial number 65, only then the petitioner has come with this challenge, with this petition, present petition. Your lordship, 4.3, that the addendum dated 19/4/2019 as a conscious policy decision of the state in the interest of public welfare. That the addendum is made of the examining and considering the entirety of the matter that relates to compassionate appointment in the state, which is in consonance with the Nagaland rules of executive business and an exercise of the powers conferred by the clause 2 and 3 of the Article 166 of the Constitution of India, your lordship. Your lordship, number 4.4, that the petitioner must come before this court, before this honorable court, not only with clean hands, but also with clean heart, clean mind, and clean objective. However, this elementary requirement is sadly absent in the present petition, and therefore the present petition must be dismissed at the threshold as being frivolous, vexatious, and whimsical in the interest of justice. Lordships, the last one, that the prayer of the present petition is verbally onerous. It is being made to circumscribe, overturn, and undermine the policy decision of the state. By the very nature of the prayer, it is understandable that the petitioner is trying to find a way of getting around to outweigh and frustrate a benevolent and just policy decision of the state.
Yes.
Yeah, let's submit more, your lordship, since your lordship has heard my learned friend and you know all the facts of the case. My submission is limited to that extent. How can the petitioner can come to overthrow a certain policy decision of the state? But that is the only reason. Your lordship, I'll give you two authority. I don't have the book with me, but 2001, volume 10, SCC, page 75.
75. Para,
page 75, your lordship.
paragraph.
Lordship, I could not make out the para, but it says, your lordship.
So I'll have to find out. Paragraph.
Once you know the page, you will know. It says, so long as the government decision is not actuated with any malice or is not the outcome of an arbitrary or whimsical act, the same should not be interfered with by the court under Article 226. Once you read the whole page, you'll know your lordship. Now,
I'll, this court has to read the entire book.
no, that page is there, page 75, your lordship.
You find out the paragraph and submit.
Paragraph will be there.
I'll read the paragraph, not the entire page.
And your lordship, 2010. Next, your lordship, 2010, volume 6, SCC, page 373.
373.
Para 19 and 20, here para is there.
Okay.
The government cannot be tied down to any policy. It can change its policy. It is not proper for the court to interfere. So now, because the government feel that the policy dated 2015 was having some trouble, so we have to give relief to all the petitioners. That is why we after giving very thought, we have molded the idea that let this first maybe the scheme.
Yes.
So, lordship, that is all my points, but I am just trying to place before your lordship that where is the enforceable right of the petitioner has been violated.
So the writ petition is not maintainable.
It's not maintainable. It should be dismissed from the threshold, your lordship. Because you see, as I said, the police department is challenging. Is challenging one petition is challenging one list. So how can for that list all the scheme should be thrown away? So, your lordship, that is my submission. Other facts, my friend who is representing the department, I think he will say. Obligation.
So your is on preliminary issue that it's not maintainable because it's a policy decision.
Yes, your lordship.
Your submission is that since this is a policy decision of the state,
your lordship,
which doesn't violate any fundamental or enforceable right of the petitioner, therefore writ petition is not maintainable.
Yes, not maintainable.
So you will not argue on the merit, how this how you are implementing this
merit of the petition. I think the respondent number 3 and 4
who has prepared the seniority list and all, who is applying the
it pertains, this petition pertains to the department.
The
department to whom you represent.
Okay. You are 2, 3, and 4.
Yes, 3 and 4, my lord.
Okay. 2. Okay. Okay.
More burden has been shifted. Yes, more burden has been shifted upon the department, my lord, which is an implementing agent.
No, that's what I'm saying. Now, forget it's whether it's bad or good. Assuming that this is good, your addendum. It's a good policy or good addendum. The application is the problem.
Yes.
On the facts of this case. So you justify that.
My lord, the OM of 2015 says that every department should have a list of applicants for compassionate appointment. Accordingly, the department is maintaining a list. The petitioner has challenged that case is not being considered for appointment in WBC 21 of 2020, and this honorable court by order 14/2/2020 has directed the response to consider his case within 2 months. Accordingly, the department has considered his case basing on the addendum of 2019. So, as per the addendum, it says that the list should be prepared as per the date, not from the application. So accordingly, we have applied that, and then we have come up with the list. We are saying that we are not considered, but we will consider his case as and when his turn comes, because there are other applicants. And if we are to go as per addendum, his case comes at serial number 50. That's why we have come up with a list of applications maintained in the department, which was challenged in the subsequent, in the present petition, my lord.
Yeah, thank your lordship. I'm calling in the other court.
Yes, yes. Sure, sure. Give preference.
So we have come up with a list. Now, the petitioner is not satisfied with this list. And then she has put a challenge in WPC 115, which is the present petition. Whatever direction this honorable court has given, we have come up with this. And then we are only an implementing agent. The government addendum is clear that for consideration of application appointments on alternate or conventional ground, it has to be from the date of date. So accordingly, we have done that. And then, my lord.
So you as learned senior counsel, learned senior government award has submitted on the validity,
Yes.
the legality of the addendum. That we have understood, we have taken note of. But another impugn challenge is the seniority list, which
Yes.
you have prepared. You
Yes.
justify that. You have seen it. You have asked these people to apply in 2021 and 22, whose father and whose the died unfortunately 10 years, 20 years back. How you can do that?
My lord, the department prepares list from
You
time
tell
to
us
time.
what is what is why this is this scheme? The purpose of this scheme is what?
To give immediate relief.
Then
The family members of the deceased government
Yes.
employees.
then you have the policy may be good,
Yes.
but how you implement it, that has to be you justify.
Yes, my lord. I'm just, my ground is that, my lord. In terms of the addendum, the subsequent list was prepared, my lord.
Yes,
Earlier, when the addendum was not there,
yes,
it was being prepared as per the application
application,
they
yes,
received. But in view of the subsequent addendum,
yes,
since it is a policy of the government, we being the implementing, we are being a department only, we have to comply with the notifications and directions of the government, my lord.
correct, correct.
So we are,
Nobody is disputing that.
yes, that's how we have prepared this, basing on the addendum.
Yes. So your affidavit, you please directly come to page 18, your
Yes.
affidavit,
Yes, my lord. Here, my lord.
2, 3, and 4, page 18. Only one instance,
Yes. Page.
serial number 2.
Yes, my lord.
We are not concerned on because there is no application.
My lord.
See, serial number,
My lord, I may be allowed to make this rectification on this.
yes,
After this was being,
not rectification, you have to justify.
yes, my lord. After the petitioner has challenged this.
See, what she has pointed out
My lord.
is this, the name of the deceased, date of expire is 1995.
My lord.
Serial
My lord,
number
this is
2,
not a final list. This is.
serial number 2,
My lord,
let's check it.
my lord, this is only a draft. This
And
is not yet.
where's the
finalized.
final? Where's the final? Where's the final list?
My lord, page number 17. So in view of the meeting minutes of the board has recommended for this only. So it's not yet finalized. It is yet to come, my lord.
Which the finalize, which one is final one?
My lord. the-
Page 34,
No, my lord. The list which was changed in the present petition.
yes,
There was some anomalies with it. That's why the board that was constituted to clarify that. After that, after clarification, after detection of some anomalies, the board has proposed a rectified list, which is yet to be finalized.
but in any case,
Yes. My lord.
this is the one which has been impugned.
Yes, my lord. No, not this one.
This one, page
No.
18, yes, he's in
Yes.
65, 69.
My lord. Please
Which one is the final one?
My lord, page 25. Kindly turn to page 25.
25 of your affidavit.
Yes, this is the same list continuation. These are the anomalies detected. That's why we are going to rectify this. Page
Page
25.
page 25.
Yes, multiple
Yes.
application for 1 to 6 page, in page 1, INP, so these are the anomalies which were detected in the list.
Yes,
That's why we're going to, at the next page, my lord. 26, my lord.
these are the anomalies.
Yes,
Anomalies detected.
yes. And then this is number 26, is list of applicants without details of relation with the deceased. So
Yes.
there's 3 numbers.
Hmm.
Next number, man. Next is 27. List of overage applicants for compassionate appointment as on 29/3/2023. So these are the lists who are overage for consideration. There's about 24 of them. And then, my lord, the last page, page number 34. That's why I've made a mention in the first that the department is.
Here in this list, where this petitioner's figures?
8, petitioner is at serial number 65.
Here also.
Yes. But this is going to be rectified after deleting those who are not eligible.
No.
Overage.
Somebody is there in 65.
Yes,
Somebody else is there.
65.
Yes.
James K.
Page 29.
Page 19.
Huh?
Page 19.
Which one is the final you are referring to? Which page?
Page 19 of my affidavit of district. Oh, my God. Yes, madam, page 19 of my affidavit.
Page 19.
Yes.
That's what I'm saying. You said this is not final. There is something wrong. James K.
Yes,
Serial number 65.
yes,
That is what I am trying to point you out.
yes, my lord.
You said this is not finalized. There is some mistake. Anomalies there.
In this anomalies, that's what this is, we have pointed out that there are
So which one is the final one?
we are yet to come up.
But in any case,
Yes, after rectifying.
the criteria
Yes,
which you have adopted is the same thing.
yes, Doctor.
That's what I'm trying to point out.
But my lord.
You just show me the correct one.
My lord,
What is the anomalies in this this seniority list?
that's what my lord, I pointed out at page number.
Okay, it may be of 3-4 persons.
No,
But-
and then my lord, there's many at page number 34, so there are some about 27 of them. So if these are all included, it will come to more than 100, man.
So according to you, suppose if it is rectified, which number does the petitioner will figure?
It is only the proportion, and then after deleting the names who are not eligible, we'll come out with the final list. But in view of the pendency of the writ petition, the present petition that has been put on hold.
Then you make you undertake that this is not the,
My lord,
why not relying on this?
why I am saying this is because if the petitioner succeeds in the writ petition and if the addendum is passed, the seniority list will be prepared as.
No, there are
list
two
of petitions.
things in this matter.
Yes, my lord.
First one is addendum
Yes,
that will consider.
yes,
She made an argument. You cannot have this kind of addendum. Second is that if addendum is not interfered, but then the application of addendum is the second leg of her submission. Suppose this court held that you can have this policy or this is upheld. If we uphold this addendum, then the application will comes into play. Ultimately, he wants an appointment. It's not a charity she's doing.
no, my lord. If the addendum is allowed to stand also, the government, the department.
Moreover, there be a contempt petition pending against you.
Yes, my lord. But contain, my lord, in view of the filing of the subsequent petition.
So when did you have this this is of when did you prepare this list?
After the meeting of 12/8/2022.
22.
Yes.
Till today you have not rectified.
No, my lord, in view of the pendency of the petition, my lord, as I've said.
No, is there any bar?
No bar. But-
Contempt is against you.
My lord,
Contempt is pending.
yes, my lord,
You said you are considering.
my lord, as directed by this honorable court.
Then
we have come up with a-
you undertake before this court that this you are not relying on this the seniority list.
My lord, as directed by this honorable court, we have issued one seniority list, which was updated as on 16 March 2022.
Where it is?
That is there at the writ petition. Writ petition, page number 44.
Huh?
Writ petition, page number 44.
44.
Yes.
Yes,
was issued. And then here, the petitioner's name is at serial number 65.
same thing,
Not 65, 66, my lord, 66.
whatever,
Going
huh?
up
61.
66, my lord.
This is just a drama, Lordship.
My lord. So being not satisfied with this, she has filed WBC 115, which is under challenge.
We have understood
So we have already come up with a.
what this court was hearing. We have heard her.
Yes, ma'am. So in view of the addendum only, we have prepared this.
This is of 16 March 2020.
Yes.
By affidavit, you are saying that this is under consideration.
This was issued since they were.
Even after more than a year, you are not able to complete the process,
No, my lord, we will complete.
despite pendency of the contempt. In that case, we'll take up the contempt first, not the writ petition.
No, it's to be issued within a short time. It's almost completed.
Issue by tomorrow. We'll see.
One within a week, we will issue.
You are saying that you are not relying on this.
No, this is the recommendations given by the board, the compassionate appointment board, because the department has constituted a board to look into the matters relating to compassionate appointment.
Are you disowning this seniority list,
Which I have enclosed, my lord.
which is impugned here?
This
Your seniority list,
No, we are
which
not,
has been
we are not
impugned here.
disowning this.
If you are not disowning, then come to this serial number 2, page 44.
Yes, my lord. Here, my lord, serial number 2.
Yes, serial number 2,
Here,
1 instances.
yes, serial number 2.
Date of receipt, that is 7/1/2022.
Yes,
Huh?
yes, my lord.
And date of expired, 1995.
Yes, my lord.
Huh? How many years? After how many years? Application.
After about nearly 2 years, 18 years.
Huh?
After 18 years.
25.
No, not
7.
This
Cell
one,
number 1 is,
27 years.
27 years.
cell
How-
number 1 is 32 years.
Huh?
Cell number 1 is 32 years.
Okay,
After
it's okay, but there's no, application, date of application. Serial number 2,
Yes.
27 years.
Here, my lord. In the recommendation made by the
27.
committee also, her name is here at page 34, my lord. Of the
Huh?
affidavit of at page 34.
34 or your 44, same list.
So, my lord, just clarify this one, my lord. One time, 34, page 34 of my affidavit. The name at the person at serial number 2, her name is also there.
Page 34.
Yes, my lord. Serial number 1. Serial number 1, which is the person which your lordship has noted. Serial number 1. That's a lot of that. Serial number 1, which is now. Is the same person.
Yes,
Yes, this is the list of applicants not eligible for compassionate appointment as per oil solicitation. So her name will be deleted, my lord.
list of applicants not eligible for compassionate appointment as per.
So her name is going to be deleted, my lord. These are the names which who are deleted.
Why not eligible?
Because as per lordship, my lord,
Sister.
it's a system.
Okay, then give me another example. Which one? Serial number 3.
Lordship, my kindly come to my 44, page 44 also.
So, my lord,
Yes. Then let us come to this serial number 4.
Serial number 4 is.
wife, they're eligible.
Yes, eligible, but then this date of the
No
point,
date of birth.
Don't for.
date of receipt.
Date of receipt is not. There is no qualification, no date of birth.
That is of 2004.
Yes, and 2000,
Application is 2022.
2022,
Yes, this is also 17 years,
18 years.
17, 18 years. 18 years.
Till the last, I have, in my application, I have worked out till the last,
Yes,
more than 7 years.
yes.
So Lordship. as
Lowest
per-
is 7 years.
till the last is 7 years at the time when they applied.
Mhm.
So the law of the land has to be applied in lordship. There has to be a specific.
You have to answer this. How you are justifying?
All these are not eligible.
Just for example. And not an example, it's clear by your own documents. Just because you have issued the addendum, the government has issued the addendum. Thereafter, you ask these persons who are sleeping.
No, my lord, it is not us which we have asked. It is them who have applied, the applicants have applied.
Then you have to have that. You have to apply it properly. Pushing back the petitioner to 66.
Yes, my lord. If it is to be considered from the date of application, her case will come at number 1.
Number 1.
In any case,
Yes.
this addendum, even if you will hold that it is correct, you can have this policy, but in any case, it cannot be made applicable to him because he applied in 2016. Your addendum doesn't say anything about the retrospective, whether this will apply retrospective or prospective. But normally, whether the policy and all, you cannot have you can push back. It's always prospective, unless it is expressly provided.
Yes, it has to be prospective.
So if the facts remain that if you don't apply, if you apply correctly, either don't apply in the case of the petitioner, or if you apply correctly also, he is number 1.
If it is to be counted from the date of application.
Yes.
Yes. And then if it is to be considered from the date
You may apply this addendum after 2019.
Yes.
Those applications who have filed after 2019, you apply this addendum. Suppose a person, for example, serial number 2 or 3 or 4, whatever. If a person applies, coming to know by taking advantage of this addendum after 30 years, will it not your duty to examine and reject it? By taking into the whole purpose of your own scheme, it is to tie over the financial which they are facing. It should be immediately, as the petitioner has also applied. 28, father died. 38, he applied. Of course, through the Honorable Parliamentary Secretary, there is another issue. At least reasonable time. Obviously, if you apply this kind of the policy which you have by applying the constitutional the authority, the power which you have enacted a policy, if you are misinterpreting it, misusing it, what's the purpose? So there's no justification about your application of this.
No, my lord. This was as per the, that said it like, my lord, I have not much to say. As per the addendum, we prepared this. I think that it was because it doesn't say anything about retrospective or prospective. And then after
Therefore, you apply it Holmes and Francis. Is it your submission? Since it doesn't say about whether retrospective or prospective, you can use it with your own.
No, my lord, it says only in continuation.
In continuation.
Yes. So, my lord,
After 2019, you apply. Those applicants.
Yes, my lord.
And if somebody comes, why this court, we are not advising you. But you must know how to implement your own policy.
Yes, my lord. That's why, my lord, we are coming with.
It's not a kind of, it's a welfare kind of policy
My lord, that's
on
why,
human consideration.
my lord, my humble submission is, that's why we are saying, that we are coming with a new list.
Huh?
We will come with a new list of applicants, and the name of the petitioner will be placed as per,
Sir,
after considering all.
we are hearing this matter since morning.
Yes, my lord.
It's nearly, it's 3 o'clock. You could have come prepared.
No, my lord, what I'm saying is that if a direction is given for,
Yes, Lordship.
for rectification of the anomalies and to come out with fresh list of applicants.
Lordship, in
At
the,
this stage will not. Whatever you want to do it. Contempt is pending. I'll segregate the contempt. I'll decide this matter.
yes, Lordship, that
On a-
will
on
be
its own.
exactly the contempt.
I'm not
can-
saying unless I sign the order, I don't know which side this will go.
Lordship.
I'll examine, I'll determine. This court will determine on the basis of the materials and the law. But prima facie, by your own showing, the impugn seniority list, this is something cannot be permissible, permitted. Do you agree?
Yes, my lord. Yes, this, if the petition will be decided, and then based on the.
This
Or if you admit that you undertake, appoint her, appoint him. Since
Lordship,
if you are admitting that if we properly implement and if you don't apply this addendum, he is incident number 1.
very much, Lordship.
My lord, but,
Why trouble all of us? Appoint him.
no,
In
we
the
are not-
interest of justice, Lordship, I will humbly pray.
No, my lord, as very oil of 2015 also, there's many guidelines laid down, so we have.
We have read it. We have
Yes,
read
yes,
it.
that's fine. After, if she.
Do you want to
fulfills-
read again?
No, 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 if he fulfills all the criteria, we'll definitely open as per the list prepared.
But not by addenda. You don't apply, you cannot apply the addenda to him. This is the primary view.
Yes, as per the OM of 2015, we will consider.
Lordship, in the interest of justice, let the contempt be kept pending, and Lordship will have a meticulous have understood the meticulous fact of the case. So a direction, a stringent direction can be given so that they can, as per the direction, they can
Stringent is-
rectify the whole.
Madam, we cannot
system.
just think of stringent unless we find something very stringent been done. We'll decide this.
Yes,
We'll
Lord.
keep we'll segregate the content.
Yes, yes.
Anything you want to submit, anything more?
No, 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 not much, that's
Huh?
all. And then I,
Contempt may not be closed, Lordship. We will await the outcome.
We'll segregate it.
Yes, Lord.
Because you said, you have not said that you have complied with. You said it's
Yes.
under still process.
yes,
And you are
once we
also-
come up with the list where her name was placed at 676.
Whatever
Yes, but. that was-
contempt, whatever
was made
steps
unchanged.
you want to take, you take. If in the contempt, if you appoint her or him, matter, contempt would be closed. Consider and appoint, contempt would be closed. This will have a different order. This will this contempt. Contempt, huh? In contempt, item 6, na? Contempt heard so and so, learned counsel for the petitioner and as well as the Mr. or alleged contemptor. Affidavit, you have filed the affidavit.
Yes,
Mr. So and so learned counsel appearing on behalf of alleged contemptor submits that he has filed the affidavit on behalf of the alleged contemptor. However, we would like to obtain further instruction whether the process has been completed or not. Mr. List this matter after prayer is allowed. List this matter after 3 weeks. Item 7. How many? Not this list. Some are okay. So we'll pass the order.
Yes.
Heard Mr. MS Judge Land counsel by the petitioner. And also heard Mr. Moy Imchet, Leonard Senior Government Advocate for respondent 1 and 2. And Mr. For respondent number 3 and 4. Hearing is concluded. We'll pass the order.
I just humbly pray that that addendum class 1 will not be exploited and manipulated by the respondents.
I'll see.
Henceforth, Lordship.
I'll see.
Yes, it's very important. Lordship. Obliged.
I cannot say now.
Obliged, Lordship.
No, keep it there. We'll be- Here's two decision I kept here. We put here in this. Two judgment I kept here. Single one. The GLT. Yes,
Lordship,
yes.
my prayers are complied, so the case may be closed.
This is what? Contempt.
No. For, Lordship, for disposal of representation pending before the.
You're complied with.
Yes, Lordship.
You got the relief.
No, Lordship, it is just for the disposal of representation. So it is now considered.
Consider. So it is, you are withdrawing this.
Yes, Lordship. So,
Mr. So-and-so, learned counsel for the petitioner submits that the respondent, the petitioners have been granted the relief as set for in this petition. Therefore, he would not press this petition. In view of the above, the writ petition is closed and disposed of.
yes, Lordship.
It's in admission.
My Lordship, here, I'm yet to receive affidavit in opposition.
Where's the government advocate?
Moyen sila.
Well, give them some time. Office note dated 2/3/2023 reflects that counter affidavit has not been filed by the state respondents. List is after 3 weeks, so as to enable the state respondents to file counter affidavit. You just heard so and so.
Lordship, here the petitioner is praying for regularization, Your Lordship. The petitioner is.
No affidavit in opposition.
It's
We'll give them some time. All right. Heard MS so and so learned counsel petition. Office note dated 10/2/2023 indicates that the state respondent is yet to file their counter affidavit. Accordingly, list is not accordingly, list this matter after 3 weeks so as to enable the respondents to file their counter affidavit. Which 38, whatever 35 and 36.
Yeah, mentioned. Before plans.
Okay. 38, yes. Service report awaited.
Yes, Your Lordship.
So we'll wait for some time, or will you take Procedural?
Your Lordship, sometime may be granted.
Okay, so we'll MS Atsula.
No, Your Lordship. Miss Kirkison.
So and so, learned counsel to the petitioner. Office note indicates that office note dated 18/4/23 indicates that service report upon the respondent are still awaited. Is still awaited. List this matter after. Not office note dated 28/6/2023. List this matter after 3 weeks.
May it please your lordship.
Where's the appellant?
Lordship, there's for order dated 1/5/23 for ends of justice. Census was given, and then your lordship for the past 1, 2, 3, 4, 5, and including today 6. On 6 occasions, they are not appearing, lordship. So we have filed one IA for withdrawal of the 50% of amount which was deposited by the Adelaide Insurance Company, your lordship. So office note suggests that the notice is still awaited. However, lordship, I have a small submission that from past last year, from October, they are not appearing, lordship. So the claimant respondent may be allowed to withdraw that amount, lordship.
No, this 7/6, you moved this IA on 7/6.
Yes, lordship.
Now we'll wait for some time in that case. Had he,
I'm taking the steps, lordship.
yes. You see? You've taken the steps on 9th,
Yes, lordship.
9th of June. We'll wait for some time.
Otherwise, also, lordship, they have deposited the.
No, but then it's okay, since notice has been issued to them. We'll wait for some time. It's a matter of another 2 weeks, we'll wait, 3 weeks, we'll wait. Okay,
In that case, lordship, let the matter be come up on 18th, lordship.
okay. Mr. Intiwapang.
Yes, lordship.
Learned counsel to the applicant, respondent, claimant.
Claimant.
Office note. No, no. This application is for, this application has been filed for filed seeking permission to withdraw 50% of the awarded amount deposited by the appellant. Notice was issued on 7/6/2023. The office note dated 9/6/2023 reflects that notice upon the respondent. The service report is still awaited. List this matter after 3 weeks.
On 18th, lordship.
On 18/7/23.
Oblige, lordship.
Computer section. Court khatam ho jaye.
On which the respondent number 23 shall file their respective affidavit as to why. They shall file their respective affidavit showing cause as to why contempt proceedings should not be instituted against. Stop. The order dated 2/12/2022 passed by this court, keeping the impugned order 19/11/2022 in abeyance, is made absolute. Listed on 17/7/2022. Whatever you have to do within these days, you do. Mr. Ma, please, next date, I think if you're also wanting to stay in Dimapur so much, you may also have to face contempt.
Lordship, I'll join immediately.
Pardon?
I'll join immediately, Lordship.
Please, after that only we will hear your petition.
Lordship.
Maybe, I don't know whether you had a good case or not, but you had satisfactorily explained your position, but certainly this court finds that there is a prima facie contempt.
Lordship. Okay.
Mr. Moa,
Lordship.
you please come with proper instruction.
Lordship.
Instruction, tell them to file affidavit, and then whatever orders has to be passed.
Lordship.
Take immediate steps.
Lordship.
We cannot allow, because actually, we cannot allow somebody to actually undermine the temple of justice.
Lordship.
Okay.
Obliged. Obliged.